Students are joining. We'll start in 2 minutes. Hello, good morning, and welcome to Baiju's exam prep. Before we start, I have an important announcement to make. Uh, I told you previously that we will have a class today and tomorrow the batch would be over. But I am going to extend this to Tuesday as well. Originally, we had planned to finish these classes on Tuesday, but since I took a few extra classes, I thought I would be able to complete the syllabus on Monday because I had to travel. Now, what I've done, I looked at the syllabus. In a sense, I looked at my PPTs, what needs to be covered now, and I don't want to rush. Uh, that would be dishonesty. So I've cancelled my travel plans. I won't be traveling on Tuesday. I'll take the last class on Tuesday. So today and tomorrow we will be discussing elections. We will be discussing the previous year's question papers, and as originally scheduled, we will have a doubt class on Tuesday. So doubt class on Tuesday stands from 6 a.m. to 9:30. Clear? Okay. Today's class continues, regardless of what happens. Tomorrow's class timing, Tuesday class timing, same as it is, 6 to 9:30. What about today's class? Depends on you. If you push me hard, ask me good questions, engage with me, I will extend the class. If you bore me, I'll end the class by 9:30. Okay. Now let's look at elections. Whether a country is really democratic depends upon existence or absence of free and fair elections. Even in dictatorial regimes where we have a dictator, even in countries where military generals are ruling, there also elections happen. But we don't call such countries democratic because elections are not free and fair. The existence, the presence, and absence of free and fair elections determines whether a country is democratic or not. And these free and fair elections should be held periodically as well. After every period, it should not be that you are conducting elections every 5 years, but then suddenly you decide, let's not have elections for a few years. That means these elections are irregular. They are not conducted regularly on a periodic basis. After the period of 5 years is over, there has to be election. If elections are periodic, if the elections are free and fair, what do we mean by free and fair election? Anybody who is eligible to contest elections should be encouraged or allowed to contest elections. That's what we call free election. If you are 25 years of age, if you are a registered voter in any parliamentary constituency of this country, you are eligible to contest Lok Sabha election. And any such individual who is eligible, qualified to contest elections, if they are not disbarred from contesting elections, if they're allowed to freely contest elections, we say the elections are free. But elections should also be fair. That means, what if all these candidates who are eligible, they are allowed to contest elections? And when people vote for them, we don't count their votes. The election commission does not count their votes. The election commission says their votes are invalid. And we will only count the votes which are polled in favor of a particular political party or the ruling political party. That means, although the election was free, but it was not fair. The presence and absence of free and fair election held after every periodic election, that determines whether a country is purely democratic or not. And elections is one tool of accountability. You are voting in favor of the ruling political party, which means you are giving a sense to the ruling political party that we agree with your policies, we respect the decisions that you have made, we are satisfied with the way you have governed the country, and we will vote you back to power. But when people come out in large numbers and vote out the incumbent government, vote out this government, then we say people are angry with that government. So, through these elections, the people keep a check on the political parties. Through these elections, people make the governments accountable. If the government is doing well, we will vote this government back to power. If not, we will throw it out, we will elect a new government. 2004, a massive campaign was launched by the BJP known as Bharat Uday, or India Shining campaign, and everybody thought that the BJP is going to sweep these elections. Elections were held, free and fair elections were held after the period of 5 years, free and fair periodic elections. Once the results were declared, Congress emerged as the single largest party. BJP lost the election. An interview was conducted with Atal Bihari Vajpayee, the then Prime Minister. And this is something that Mr. A.S. Dulat, the former RNW chief, writes in his book. He says, I went to meet Atal Bihari Vajpayee and I asked him what happened. He said, even they don't know what happened. They means on the opposite side was the headquarters of the Congress party. So Mr. Vajpayee is basically saying, I don't know what happened. Even the party which has won the election, they also won't know what has exactly happened. But then writers, columnists who look at the government, who understand how the governments function, they say that it is because this campaign, Bharat Uday or India Shining campaign, failed and ultimately led to the downfall of the BJP government. Why? Because they say that India was shining in the urban areas, the urban infrastructure was picking pace, but in the rural areas, India was still poor. Farmer suicides, farmer distress continued. People were not able to meet the two ends. 2004, Dr. Manmohan Singh came to power, did a spectacular job in his first term as the Prime Minister for 5 years, remained rock solid despite the fact that some of his own coalition partners, for example, the communists, they decided to withdraw support to his government because he wanted India-US nuclear deal to go through anyhow. And in 2008, when no confidence motion was introduced against Dr. Manmohan Singh, his own coalition partner, the Communist Party of India, voted against him, but even then he emerged victorious. And the news channels beamed, Singh is king, and Dr. Manmohan Singh became the king. Not in the real sense, but king in the sense he did something good. Some of the fantastic laws were made. Not MG Narega, some of the fantastic laws like Right to Information Act, like we saw the Forest Rights Act. Brilliant social security schemes were implemented. 2009, people voted for him again. So it was not the victory of the Congress party, it was the victory of Singh is king in 2009. But then came the period of policy paralysis. where people thought that Dr. Manmohan Singh is not in charge, where decisions could not be taken, where there were allegations of massive corruption, whether it is 2G, whether it is Commonwealth game scam, whether it is Adarsh housing scam, so many scams, coal scam unearthed during this period. People decided to teach him a lesson, voted him out of power, and brought Mr. Modi as the prime minister. People were satisfied with him in 2019 and voted him back to power in 2019. Now, in the next election, in 2024, after the period of 5 years, free and fair elections will be conducted by Election Commission of India. If the people are satisfied with Mr. Modi's government, they will vote him back to power. If not, someone else will be elected. Which means elections is also a tool through which the people of a country hold its government accountable. If you're satisfied with the government, you will bring that government back to power. Otherwise, you will bring in someone else. But today, people vote in these elections not only, this is the very important point, not only to elect a government, but also to choose an opposition. People come out in large numbers to vote for a particular political party so that this political party is able to form the government. But that's not the only job of the elections. The job of the elections is people also get to decide who should be the opposition. If the Congress party was relegated to the status of an opposition in 2014, is it doing good, bad, or ugly in terms of being a strong opposition? Is the Congress party able to hold the government accountable on the floor of the parliament, criticize the policies of the government in an effective manner? We will elect BJP again, but we will choose Congress again as the opposition because it is doing something credible. If not, we will choose a different opposition, maybe the Aam Aadmi Party. So, in the last elections, which were conducted for the State Assembly of Gujarat, people made that choice, that it was a warning signal to the Congress. If you do not get together, act together, be a credible opposition, we have another political party waiting for us as an option. We will elect Aam Aadmi Party as the opposition. So the presence or absence of free and fair elections or periodic elections determines whether a country is purely democratic or not. And what is election? Election is like the biggest festival in India. Just like we have Diwali, Baisakhi, Christmas, Eid, in a similar fashion, in a secular democracy where religion should not play an important role, one of the bigger festival is the election. Every 5 years, people choose their government and also choose the opposition and hold the government and the political parties accountable. For these elections, we have some constitutional provisions beginning Article 324 to Article 329. First, I will briefly tell you what these provisions are all about. After I briefly discuss these provisions, then we will have an elaborate discussion on the entire election process. Article 324 establishes a constitutional body, and that constitutional body is known as the Election Commission of India. Constitution says superintendence, direction, conduct, control of all elections. Whether these elections are to be conducted for Lok Sabha or Rajya Sabha, whether for president or the vice president, whether for the legislative assembly or the legislative council, the entire election process is vested under a constitutional body known as the Election Commission of India. Who conducts and organizes elections at the local level at Panchayati Raj and municipal councils? That election, you would know, is conducted and organized by the State Election Commission. But this Election Commission of India organizes elections for Lok Sabha, Rajya Sabha, President, Vice President, Legislative Assembly, Legislative Council. So Article 324 establishes a constitutional body. What is its role, function, composition? We'll discuss slightly later. But what is Article 324? It talks about a constitutional body known as Election Commission of India. Article 325, it talks about a common electoral roll. The year was 1909. Morley-Minto reforms. Morley was the Secretary of State. Lord Minto was the Governor General. Reforms were implemented. What were these reforms? Now, separate electorates were created for Muslims. That means some seats were reserved for Muslims, but only Muslims could contest these elections. Only Muslims could vote for them. That means from a particular constituency, there are some seats reserved for Muslims. Only Muslims can contest these elections and only Muslims can vote. And this ultimately, this separate electorate or communal electorate was later extended for Anglo-Indians as well, Christians as well, and over a period of time, it was thought to be applicable to Dalits as well. But then a massive protest was launched by Mahatma Gandhi. He went on fast unto death, saying if you create a separate electorate for Dalits, where constituencies are reserved for Dalits, where only Dalits could contest and vote in these elections, this will take Dalits out of the Hinduism fold. This is something which is not acceptable to us. So over a period of time, Dalits can constitute a different religion. Ultimately, there was a compromise between Dr. Ambedkar and the Mahatma. Pune Pact was signed by the two leaders, and the separate electorates for Dalits was done away with. But long story short, there used to be separate electoral rolls. That means from this constituency, only Muslims can vote. From this constituency, only Sikhs can vote. And this process, this ideology led to the division of this country, sowed the seeds of division, which led to the partition of this country in 1947, unfortunately on the religious grounds. Then when partition happened and we have a constituent assembly, which is now drafting the constitution for the independent India, they realized that this mistake we will not repeat again. So we will not have a separate electoral system or separate electoral rolls or communal electoral rolls, where from a particular constituency, only a particular religion can contest election. Only the members belonging to that religion can vote. This is something which is against the secular idea of India. We will not accept this. So we will not have a separate electoral roll for different communities or even different castes. We will not have a separate electoral roll, but we will have a common electoral roll. And no community, whether it's a religious community or a caste community, can demand that we should not be included in this common electoral roll. We should be included in a different electoral roll. That's something that is not acceptable to us. Article 325. But sir, there are seats reserved for SCs, there are seats reserved for STs in Lok Sabha, in state assemblies. What about that? Number one, it was meant to be for 10 years. This political reservation for SCs and STs in legislatures in India, it was not meant to go forever. It was only meant for a specific time period for 10 years. But because of the lack of political consensus or because of social justice, this reservation or political reservation for SCs and STs continues even today. But even if it continues, it does not violate Article 325. Why? Because even if seats are reserved for SCs or STs, let's say these are 80 seats reserved for SCs, that means only SCs can contest. But that doesn't mean only SCs can vote. Any voter in that constituency, whether SC or ST or OBC or a general category, whether Hindu, Muslim, Sikh, Christian, Parsi, of any religious denomination, can vote in these elections. Yes, only a reserved candidate can contest election, but who can vote? Anybody who is the voter of that constituency. So Article 324 establishes a constitutional body known as Election Commission of India. What exactly is the role of this body? We will discuss slightly later. Article 325 talks about a common electoral roll. That means all the voters will be mentioned in list. All the voters of this parliamentary constituency, there will be one common voter list. And no community or caste group can demand that we should not be added in this electoral roll, we should have a separate electoral roll. And we will not have constituencies reserved for certain religious communities, so that only that religious community can contest election and vote in the election. That's something which is not acceptable. That's Article 325. And Article 326 talks about universal adult suffrage. Previously, the voting age was 21. Rajiv Gandhi was the prime minister in 1989. The voting age was reduced to 18. Now, anybody who is above the age of 18, regardless of your religion, regardless of your caste, regardless of your gender, regardless of your educational qualifications, regardless of your economic status, you have the right to vote. And this is something unique. This is something brilliant. In one go, in 1950, we extended right to vote. Constitution provided right to vote as a constitutional right to all adult citizens of India, which was not seen in other so-called progressive countries. For example, Switzerland gave voting rights to women in 1970s. England gave voting rights to women in the 1920s. Same goes with United States of America. That means these so-called progressive, liberal, Western democracies, they did not trust women with the right to vote until recently. There was a time when only the rich, those with a specific economic status, could vote in these progressive countries. Even in India, during the British rule, when provincial legislative assemblies, elections could be held at the provincial level, at the local level, right to vote was not given to everybody. Right to vote was given on the basis of educational status, on the basis of economic status. But in one fell swoop, in one single go, where people thought in the West that Indian democracy as an experiment is bound to fail. What is India doing? Everybody started paying attention to India. That now they have become independent in 1947, and within 4 years they have a constitution, and they have set up a parliamentary democracy, and they are going to hold elections where they are providing right to vote to everybody. This experiment is bound to fail. So people were looking at India so that they could tell, I told you so. I told you that India is going to be destroyed because of its experiment with democracy, because of its experiment with universal adult suffrage. And we proved all these naysayers wrong, and today India is the largest democracy of the world. Right to vote is a constitutional right. Every adult who crosses the age of 18, regardless of your caste, regardless of your gender, regardless of your religion, your educational qualification, your professional status, your economic status, you have the right to vote. In previous judgments of the court, multiple judgments of the court had said that right to vote is a statutory right, not a constitutional right. Statutory right provided under the Representation of the People Act 1951. But later, Supreme Court has clarified that right to vote is not a statutory right. It is a constitutional right under Article 326 of the Constitution? In fact, this is a question that was asked in one of the prelims examinations as well. Article 326. Article 327 and Article 328 are more or less similar with some distinction. Similar because Article 327 empowers the Parliament. The dear Parliament, what you can do, you can enact laws. And through these laws, what you can do, you can make provisions with respect to elections to the legislatures. That means what Constitution will say, that election holding will be the responsibility of the Election Commission of India. But how election is to be conducted, who should be qualified to contest elections, who should not be qualified, whether additional disqualifications can be prescribed, whether additional qualifications can be prescribed, what if there is a dispute in an election, how political parties will be recognized, how symbols can be given to them, whether we will use electronic voting machine or ballot paper, how do we fill the nomination papers, who will be the returning officer? Because Constitution cannot talk about all these details. That is why Constitution has left this matter to the Parliament. Dear Parliament, you can make a law and you can govern the conduct of elections to legislatures. And you can pass this law not only to govern the conduct of elections to Parliament. That means you may not only make law for yourself, Lok Sabha and Rajya Sabha, you can also make law for the state legislatures. That means elections to Lok Sabha, Rajya Sabha, to Legislative Assembly, Legislative Council, to govern the conduct of these elections, their Parliament, you have the power to make laws under Article 327 of the Constitution. And Parliament has made various laws. President and Vice President Elections Act, Representation of the People Act 1950, Representation of the People Act 1951. These are two major election laws that we will have to discuss in this chapter, elections. Similar power is given to the state legislatures under Article 328. Their state legislature, their legislature of Karnataka, you also have the power to make a law, to make provisions for the conduct of elections to your own legislature. Madhya Pradesh legislature has the power to make a law to govern the conduct of elections to Madhya Pradesh legislature, provided Parliament has not made any law. So if Parliament already has made a law, that parliamentary law will apply to Madhya Pradesh Assembly as well, to Karnataka legislature as well, to UP Assembly as well. But if Parliament has not made the law, then state legislature, you have the power. What you can do, you can enact a law. Through this law, what you can do, you can make provisions for the conduct of elections to your own legislature. But since Parliament has already made laws like Representation of the People Act 1950, Representation of the People Act 1951, that is why states do not have their own laws for the conduct of elections to their own legislature. But they have made laws for the conduct of elections to the local bodies, whether it is the Panchayati Raj institutions or municipalities. Because every Panchayati Raj institution, every municipality is set up based on the law passed by the state legislature. And you would know, when state legislature enacts such a law, it has to compulsorily include provisions of 73rd Amendment. And if it wants, it has to include the optional or voluntary provisions of the 73rd Amendment as well. So what is election? Election is basically a tool to hold the government and the political class accountable to the public. Through regular, periodic, free and fair elections, we can determine whether a country is democratic or not. Election is a tool not only to choose or select a government, but also to choose and select an opposition. What are the constitutional provisions regarding elections? Article 324 establishes a constitutional body known as the Election Commission of India. Article 325 talks about a common electoral roll, not a separate or communal electoral roll. Article 326 talks about universal adult suffrage. Every adult above the age of 18, regardless of other considerations, you have the right to vote. Article 327 empowers the parliament. You can make a law for the conduct of elections to parliament and other legislatures. Article 328 empowers the state legislature. You can also make a law for the conduct of elections to your own legislature, provided parliament has not made the law. But since parliament has made laws, and there are two important laws that we have to discuss, Representation of the People Act 1950 and 51, that means state legislatures have not enacted their own laws for the conduct of elections to their own legislature. But Article 329, bar to interference by courts in electoral matters. That means in electoral matters, there can't be an interference by the courts. And what is that electoral matter? Delimitation. What is delimitation? Redrawal of electoral boundaries known as constituencies. Constitution says after every census there should be delimitation. What is this delimitation? A redrawal of the electoral boundaries or constituencies in India. Why? So that one person, one vote is followed. Can we call ourselves a democracy if I can vote twice, or if the value of my vote is 2 and the value of your vote is only 1? We can't call it democracy then, because the election process is not free and fair. There are some people who have a higher voting value as against another person. That means if all the people of this country are equal, and the constitution begins with we the people of India, that means every person will have one vote and the value of this vote throughout should be same. For that, what we need to do? We need to conduct the census exercise. Census exercise conducted every 10 years normally is the head count. That means we have to look at what is the exact population of this country, and then look at what is the population which is above the age of 18, because these are the people who have the right to vote. And we will divide all these people equally, so that in every constituency in this country, if there are 1 crore people, we will divide it into 100 constituencies. If there are 10 crore people, we will divide it into 1,000 constituencies, so that in every constituency, the value of vote of an individual remains the same. In a sense, we will divide the entire country in such a manner that if the population of UP is 10 crore, it will be divided into 10 constituencies, so that in one constituency, there will be 1 crore voters, and all the voters will have the same value, 1 vote. Which means next constituency in UP will also have 1 crore voters, and will also have 1 crore voters, the value remains the same. But in Kerala, there are 5 crore people, will be divided into 5 constituencies, so that every constituency will have 1 crore people. Which means throughout the country, we will not find a situation where there are 1 crore people represented by 1 member, and in other states there are 1 crore people represented by 2 MPs, because then the value of vote is higher. 5 lakh people, 50 lakh people represented by 1 individual, but in another state 1 crore people represented by 1 individual. This should not be happen. This should not be allowed. That is why after every census, whenever there is an increase in the population, Wherever there is increase in population, give them more MPs. So that throughout the country, one person, one vote formula is followed. And who will redraw these electoral boundaries? Will not be done by the government, will not be done by the legislature, will be done by an independent body known as Delimitation Commission, which is basically a statutory body. It's not created by the constitution, it's a statutory body. Delimitation happened after the census of 1951, delimitation happened in 1952. After the census of 61, delimitation happened in 1963. After the census of 1971, delimitation happened in 1973. And in all these instances, the seats got increased. Because as the population increased, wherever the population has increased, for those areas, extra seats were provided. So that throughout the country, one person, one vote is followed. Which means from 489 to 513, then to 543, we saw the increase in the number of seats after every delimitation, after every census. But then the southern states protested. Why? Southern states approached the Prime Minister, Srimati Indira Gandhi, Madam, please save us. You are incentivizing those states which are not doing well. You are disincentivizing those states which are doing well. So what am I doing? You are carrying out delimitation after every census? Said, yeah, that is mentioned in the constitution. I can't violate the constitution. If I do that, then you will claim I am a dictator, I violate the constitution. Madam Gandhi, you don't understand. Southern states are effective in controlling the population. You said, your father said that we need to control our population because the resources are limited. And we have implemented various family planning programs because of which we are able to control our population. That is why in southern states you will not see population explosion. That means we are doing good. But in northern states, and they were given a term known as Bimaru, as if these are sick states. Sick. Bimaru, Bihar, Madhya Pradesh, Rajasthan, Uttar Pradesh, a derogatory term was used for them. These are Bimaru states where population explosion has happened. And as the population explosion has happened, that means they have not been able to control their population. With the population increase, seats will also be increased for them. That means over a period of time, southern states, their representation in Lok Sabha has reduced. These Bimaru states, their representation in Lok Sabha has increased. And tomorrow, if we continue to have delimitation after every census, we will see that northern states will have massive representation in Lok Sabha. Yes, they have a massive population, but that doesn't mean we should incentivize this lack of family planning in the northern states. So there will come a time where northern states will be at a massive advantage as compared to southern states. Please do something. 42nd Constitutional Amendment Act was passed. The year was 1976. Parliament said no further delimitation till 2001. We are in 1976. For the next 25 years, there won't be any delimitation. There will be census. We will know population has increased, but we will not carry out delimitation because the southern states would be at a disadvantage. And even if we carry out delimitation in 2001, the number of seats shall be frozen till 2026. This is not an arbitrary number. 1976 till 2026, 50 years. With the assumption, with the hope that by this time our population would be stabilized. So we can conduct delimitation and we can increase the number of seats only after the census of 2026, which means after the census of 2031, can we increase the number of seats to legislative assemblies of India, to Lok Sabha as well. But we will not have delimitation till 2001. That means even after 2001, if there is delimitation, but that should not lead to an increase in the number of seats. And then delimitation was carried out in the year 2002. But then what was the purpose of carrying out delimitation in 2002 if the number of seats will not increase? In 2002, we call it internal delimitation. What is the internal delimitation? Listen to me carefully. For example, we have a state, and the state has 1, 2, 4 constituencies. Initially, till 1971, we have to value one person, one vote. That means after 1971, in 1973, when the census exercise, when the delimitation was carried out, if the population of all of this entire state is 10 crore, here we will have 2.5 crore people, 2.5 crore voters. That means 2.5 crore people will be represented by one MP. One person, one vote is followed. But over a period of time, 1971 census, 1981 census, 1991 census, 2001 census, 3 more census exercises were carried out. But we may see that within the state, when population has increased, maybe this constituency now has 3 crore voters, this constituency has 5 crore voters, this constituency has, let's say, 10 crore voters, this constituency has 5 crore voters. 10, 20, 23, or let's say 24 for mathematical understanding. That means when delimitation was carried out in 1973, after the census of 1971, whatever is the number of voters, eligible voters in the state, they were divided into 4 constituencies, so that throughout the state, one person, one vote is followed. But then in 1981 census was carried out, in 1991 census was carried out, in 2001 census was carried out, and then we saw that in these 4 constituencies, we don't see equal number of voters. In one constituency, we have 4 crore voters. In another constituency, we have 5 crore voters. In another constituency, we have 10 crore voters. In another constituency, we have 5 crore voters. Which means one person, one vote is not followed, violated. Why? Because here the people have lesser value to their vote. 10 crore people represented by one MP. Calculate the value. 5 crore people represented by one MP. That means they have more value to their vote. 4 crore people represented by one MP. That means they have a much better value to their vote. After the census of 2001, when the delimitation was carried out in 2002, that is known as internal delimitation. That means internal reorganization. That means if all the voters put together are 24 crore voters, the number of constituencies cannot be increased. Number of constituencies, number of seats remain frozen till 2026. But we will divide this 24 crore into 4 constituencies, so that we can include other areas from a constituency. That means this 4 crore people, we from neighboring constituency, we will add 2 more crore voters. Those areas will now be part of this constituency. This constituency had 10 crore voters. This constituency, a portion of this constituency will be merged with the neighboring constituency, so that the entire state, their voters are divided in such a manner that value of vote remains the same, which means these 24 crore voters will be divided again within only four states, four seats. The number of seats will not increase, but in such a manner that one person, one vote is followed, which means in every constituency now we will have 6 crore voters. That is why delimitation was carried out in 2002. And there was another reason. The reason was to increase the number of seats reserved for SCs and STs. SCs and STs, seats will be reserved for them in legislative assemblies and the Lok Sabha. This was meant to be for 10 years, but every 10 years this was extended, and in 2020 also we saw it was extended for another 20 years. But the seats which were reserved for them, let's say the seats reserved for them were X in 1951. After the census, after the delimitation of 1962, in 1963, the seats reserved for SCs and STs became Y. Seats reserved for SCs and STs in 1973 became Z. But in 1981 census, their population would have increased. In 1991 census, 2001 census, their population would also have increased. Now we need to increase the reservation for them. That means total number of seats will still remain 543. But if the number of seats reserved for STs was 60, it should be increased to 81 in 2002. Number of seats overall will remain the same, but number of seats reserved for SCs and STs will increase based upon their population. It was because of these two reasons that delimitation was carried out in the year 2002. So what is delimitation? A redrawal of electoral boundaries, constituencies, after every census exercise is carried out, which is carried out every 10 years. After the initial census of 1951, 61, 71, delimitation was carried out, which means as the population increases, so should the seats also increase. But then the southern states protested and said, please don't do this because we are at a disadvantage. We are being incentivized for doing good. And these Bimaru states are incentivized for not doing good. Constitution was amended in 1976. Constitution said, now no further delimitation till the census of 2001. After 2001, census was carried out in 2002. But the number of seats will not increase. Why? Because the number of seats have been frozen till 2026. That means the number of seats to Legislative Assembly, to Lok Sabha, Rajya Sabha cannot increase till the census of 2031. That means only after the census of 2031 can we have another delimitation which will increase the number of seats. That perhaps explains why we have a different parliament, a new parliament today, with an increased, better seating capacity to accommodate any increase in the number of seats if delimitation is carried out after the census of 2031. But then why was census carried out in 2002? Number one, internal reorganization, internal delimitation. That means if in Delhi we have 7 Lok Sabha constituencies, 7 will not become 8 or 10. 7 will remain 7. But the entire Delhi will be divided equally into voters. And the second reason why delimitation was carried out in 2002 was the number of seats reserved for SCs and STs will increase without any increase in the overall number of seats. That means Lok Sabha seats will remain 543. Legislative Assembly seats will remain 403 for Uttar Pradesh. But the reservation for SCs and STs, their seats may increase based on their population figures of 2001. But when this census exercise was carried out, when this delimitation exercise was carried out in 2002, Constitution was amended again. No further delimitation till 2026. That means now the number of seats are frozen till 2026. If the number of seats can increase, it can only be increased after the census of 2031, which means only after the census of 2031 can we have another delimitation. Now, no further delimitation can take place. But when in the year 2002, delimitation was meant to be carried out in the entire country, there were some states which were excluded. States such as Arunachal Pradesh, Assam, Manipur, Nagaland. Various organizations in these states approached the Guwahati High Court saying we do not want delimitation to be carried out according to the census of 2001. There was one more state which was excluded, that was Jammu and Kashmir. Jammu and Kashmir was excluded because of its special status. Special status in the sense, I told you in J&K chapter that no amendment to the Indian Constitution will apply to the state of Jammu and Kashmir unless and until the government of Jammu and Kashmir accepts it. When the amendment was made to the Constitution, that there will be no further delimitation and the number of seats will remain frozen till 2026. A constitutional amendment was made, and this constitutional amendment froze the number of seats till 2026. The state government said, now you cannot conduct delimitation exercise in our state till 2026. So only in 2026 we will carry out delimitation after the census of 2026. So J&K election, J&K delimitation could not be conducted because of another reason, delimitation. Another reason because of their special status. But in these four states, Arunachal Pradesh, Assam, Manipur and Nagaland, various organizations moved the Guwahati High Court saying we don't want delimitation to be carried out according to 2001 census. Why? Because during this period, illegal migration has taken place into our states. So after 1971, we have seen illegal migration occurring in our northeastern states. Assam, for example, when there was 1971 war, which led to the emergence of Bangladesh as an independent country, there was a massive migration of Bengalis to Assam. And now if you're making 2001 census as the basis for delimitation, which means you are including them as well, those who are present. In fact, you have not conducted NRC in Assam because this is 2002. But courts cannot interfere. Why? Because there is a bar on the interference by courts in electoral matters. One such electoral matter is delimitation. That means when Delimitation Commission gives its award, you cannot question this award before the court. There's a ban, there's a bar, because it's an electoral matter. It is kept outside the purview of the courts. But sir, why delimitation happened in J&K then? And if you're saying there is no interference by courts in electoral matters, then what are you saying that these four states approached the Guwahati High Court challenging the census according to 2001 census? You're saying something contradictory. When these four states approached the Guwahati High Court, it was after that that the president decided, on the advice of the Prime Minister, that we will exclude these four states. We won't carry out delimitation in these four states. So delimitation could not be carried out in these four states, not because of the Guwahati High Court judgment, not because of the Supreme Court judgment, not because of any court interference, because the courts cannot interfere in electoral matters. But it was done because the president on the advice of the Prime Minister and his Council of Ministers, decided to exclude these four states from delimitation exercise. And the President further said that whenever delimitation is to be conducted in these four states, delimitation will be carried out by Election Commission of India. That means who can conduct delimitation? Either it is a statutory body known as the Delimitation Commission of India, or it can be Election Commission of India itself. Election Commission of India itself can carry out delimitation exercise. And the President has said, on the advice of the Prime Minister and Council of Ministers, that for these four states, delimitation will be carried out by the Election Commission of India. But in 2019, when Jammu and Kashmir Reorganization Bill or Act was passed, this Act talked about delimitation, saying since delimitation could not happen in 2002 for Jammu and Kashmir, now delimitation should happen only for Jammu and Kashmir. And this delimitation will be carried out by Delimitation Commission. This Delimitation Commission will be headed by a retired judge of the Supreme Court. Chief Election Commissioner will also be part of this Delimitation Commission, and we will have State Election Commissioner or State Chief Electoral Officer also part of this Delimitation Commission. And Justice Ranjana Desai was appointed as the chairperson of this Delimitation Commission. And for J&K, the number of seats will increase. And this is how some experts and activists said, if special status for Jammu and Kashmir was revoked in 2019, while revoking the special status for Jammu and Kashmir, another special treatment was given to J&K, that for you and you alone, delimitation will be carried out, and for you and you alone, the number of seats will also increase. And the number of seats also increased. Total 7 seats were increased for this Union Territory of Jammu and Kashmir. And this Delimitation Commission said 6 seats should go to Jammu and 1 seat will go to Kashmir. Then there were many individuals who protested this, saying if we look at the population of Kashmir, it is higher than the population of Jammu. Then how can you allocate 1 extra seat to Kashmir and 6 extra seats to Jammu? Delimitation Commission said population is not the only criteria. Population is not the only criteria. We have to look at other criteria as well. For example, if there is a state where there are areas which are along the border we will always see less number of people inhabiting. But since the area is large, we will not only, just because they have a lesser population, give them lesser number of seats. So areas bordering the state, bordering the foreign countries, areas which are very difficult to inhabit, which have a difficult terrain, so people are sparsely populated there, that can also be the reason for giving them extra seat. So population alone is not the reason. This Delimitation Commission was challenged in the Supreme Court. But sir, you said there is bar on the interference by courts in electoral matters. Yes, there is. So when the final award was given by Delimitation Commission, when Delimitation Commission said 6 seats should go to Jammu, 1 seat should go to Srinagar or Kashmir, and these are the grounds on the basis of which we will conduct delimitation. On these grounds, you cannot challenge the court. You cannot have a challenge in the court. You cannot file a petition in the court. The petition was filed. Why different treatment for J&K when in the rest of the country we will not have delimitation till after 2026? Why increase the number of seats for J&K when in the rest of the country the number of seats cannot increase? On these grounds, it was challenged. So the award given by Delimitation Commission was not challenged. The very constitution of Delimitation Commission was challenged. But the court said this is part of the law. According to Jammu and Kashmir Reorganization Act, there should be delimitation for J&K. There should be delimitation. And we are talking about no delimitation for states in India, for Lok Sabha and Rajya Sabha in India. This concept of freeze or ban on delimitation does not apply to a union territory. Since Jammu and Kashmir now is a union territory, there can be reorganization, there can be delimitation, there can be increase in the number of seats. Long story short, after every census, there should be delimitation, which means the reorganization of the electoral boundaries or constituencies. Clear? As the population increases, which is reflected in the census, the number of seats will also increase. This happened after the census of 51, after the census of 61, after the census of 71. But then we saw southern states are at a disadvantage, the northern states are at an advantage. Now the constitution was amended, no further delimitation till 2001. And even if delimitation is carried out after the census of 2001, there won't be an increase in the number of seats to Lok Sabha, Rajya Sabha, to state assemblies. Why? Because these seats will be frozen till 2026. That means if at all seats in Lok Sabha, Rajya Sabha, legislative assemblies can change, can be increased, it can only happen after the census of 2031. And that is how only after the census of 2031 can we see Women's Reservation Act implemented, 106th Constitutional Amendment Act implemented. Because according to 106th Constitutional Amendment Act, seats shall be reserved for women in Lok Sabha and in state assemblies, not less than one-third. One-third seats will be reserved. But this reservation of seats, this act, this 106th Constitutional Amendment Act will enter into force after the census and delimitation will be carried out. Census which was meant to be carried out in 2021 could not be carried out because the government says there was pandemic. That means the census has been delayed. Now the government is saying census will be conducted after the 2024 elections, which means after 2024 elections, we will have census exercise. If it is not conducted, then we will have census in 2031. Then after the census of 2031, there will be delimitation. Delimitation takes a lot of time. How much time? When delimitation was carried out in the year 2002, final award was given in 2008. Final award in the sense that these are the constituencies now in India. That means if the census is carried out in 2031, then delimitation commission is set up to conduct delimitation in this country. It might take few years. That means in 2038 maybe we will have the final award of the delimitation commission. That means in 2039 elections we will see women's reservation implemented for the first time. In fact, there was a petition filed in the Supreme Court asking the Supreme Court, can you direct the state that you should implement women's reservation now instead of waiting for census and delimitation? The court rejected this petition. But when delimitation exercise was carried out in the year 2002, the purpose was internal reorganization. That means the number of seats will not increase. Number of seats will remain the same. but we will divide the population of our state, voters in our state, equally into equal constituencies. And we will also increase the number of seats reserved for SCs and STs. Their population is increased. In proportion to their population, they should get reservation in Lok Sabha and legislative assemblies. But since the number of seats cannot increase, but their population has increased, that means the seats reserved for them can increase without increasing the number of seats, total seats. But Article 329 says there is bar on the interference by courts in electoral matters. Courts cannot interfere in electoral matters. One such electoral matter is delimitation. But when this delimitation was to be carried out in the year 2002, some states were excluded. Which were these states? J&K, because it had its own constitution. Assam, Arunachal, Manipur, and Nagaland, they were also excluded by the president. Not by the court, by the president. Why? Because these states convinced the central government that our population, which you will see in 2001 census, also includes what we consider as illegal migrants. If on their basis you will reorganize our constituencies, then you are basically giving away our constituencies to illegal migrants. We will not accept this. President said, don't worry. On the advice of the Prime Minister and the Council of Ministers, I am excluding these 4 states from delimitation commission. And next time when delimitation will be carried out by Election Commission of India, not the delimitation commission. And in 2019, when Jammu and Kashmir Reorganization Act was passed, it provided for that there should be delimitation in J&K as well. And for J&K, the number of seats will also increase. But just to appear that we are not treating J&K differently, the government said, this delimitation commission, which was set up under Justice Ranjana Desai, which will have the Chief Election Commissioner and the State Election Commissioner as the members. This delimitation commission will conduct delimitation in J&K, will conduct delimitation in those 4 states as well, which were excluded in 2002, which means Assam, Arunachal, Nagaland, and Manipur. But then very quickly, very soon, a notification was issued by the government saying this delimitation commission will work only for J&K. Those 4 states will be excluded again. Why excluded again? Because a legal advice was given to the government that 2002, when you excluded Assam, Arunachal, Manipur, and Nagaland from delimitation exercise, at that time the president had said that we will carry out delimitation, but that delimitation will be carried out by Election Commission of India, not the delimitation commission. So if you are saying delimitation commission will carry out delimitation exercise in these 4 states, that would not be proper, that would be against the law. And on that ground, this delimitation commission will be struck down. And that is how the government excluded these 4 states again. But now Election Commission of India is carrying out delimitation exercise in Assam. But when delimitation was carried out in J&K, seats were also increased. More seats were given to less populated Jammu as against more populated Kashmir. This was challenged in the court. What was not challenged in the court was not how delimitation commission came up with this logic of increasing the number of seats for Jammu and not for Kashmir. Why population alone is not the only criteria. Hilly areas, areas bordering the foreign countries, those are also under consideration by the delimitation commission. This cannot be challenged because this is the job of the delimitation commission. And it is kept outside the purview of the courts. What was challenged in the court was the very creation, very establishment of delimitation commission and the increase in the number of seats. Supreme Court rejected this petition and said there can be increase in the number of seats. There can be delimitation for Jammu and Kashmir because J&K is not a state now. It's a union territory. This bar, this limit, this ban on the increase in the number of seats can happen only for this ban is only for the states, it's not for union territories. That is delimitation commission. Any questions as of now? When delimitation carried out in J&K, did this lead to increase in number of seats in Lok Sabha? No. Who gives legal advice? Attorney General, or maybe another secretary would have pointed out to the governments, we have made a mistake here. What is NRC? My dear, NRC is something that we have discussed in citizenship chapter. Okay. Now let's look at Election Commission of India. And we will understand what is the composition, what are the powers and functions, and what are the reforms needed in the Election Commission of India. Constitution says that there shall be Election Commission of India headed by the Chief Election Commissioner, and as many election commissioners as may be appointed by the President. Article 324 says superintendence, direction, conduct, control of all elections, whether to president or vice president, Rajya Sabha, Lok Sabha, state assembly, state council. The superintendence, direction, conduct, control of all these elections is vested in this body known as the Election Commission of India. But what is the composition of this body? Constitution says that the Election Commission of India will consist of the Chief Election Commissioner and as many election commissioners as may be appointed by the President. Till 1989, Election Commission of India functioned as a single member body. There was only Chief Election Commissioner. Election commissioners were not appointed. 1989, we saw the voting age was reduced from 21 to 18. And at that time, President appointed 2 election commissioners. Why? Because the government said, since the voting age has been reduced from 21 to 18, there are lakhs and crores of new voters who will get added, which means more work for Election Commission of India, which means more number of members are required to assist the Chief Election Commissioner. And in 1989, we had Chief Election Commissioner and 2 election commissioners. Why? Because Election Commission consists of Chief Election Commissioner and as many election commissioners as may be appointed by President. But after 1991, after 1989, elections were over and these 2 election commissioners were removed as well. So it again became a single member body. But then came a legendary Chief Election Commissioner, T.N. Seshan. That is why if you read newspapers, which you should, and if you read editorials and columns related to the elections or Election Commission of India, you would find a mention of this name, legendary name, T.N. Seshan, who was an IS officer, later on appointed as the Chief Election Commissioner. And my God, he did a terrific job. Ensured that elections are free and fair, did not favor the ruling political party, implemented strictly the model code of conduct, which we will discuss today, which ensures level playing field. Everybody should have an equal opportunity to win the election. When he became so independent, when he became so powerful, he was not listening to the government. He was not towing the line of the government. He was impartial in his dealings with all political parties. All political parties were affected by him because he did not favor anybody, and he, with strong determination, implemented the rules of elections in India. Then all these political parties came together. Parliament enacted a law known as Election Commission of India, Conditions of Service of Election Commissioners and Transaction of Business Act 1991. And according to this law, we will have a Chief Election Commissioner and not more than 4 election commissioners. All of them will be appointed by President. CEC and election commissioners, they will have the status of the judge of the Supreme Court. All decisions to be taken through consensus. If not, then by majority. Election Commission of India consists of Chief Election Commissioner and as many election commissioners as may be appointed by the President. 1989, 2 election commissioners were appointed. Election got over, these election commissioners were removed. 1991 now, TN Session is the Chief Election Commissioner. He is implementing the rules of the election very vigorously, impartially. Parliament enacts a law, and through this law, Parliament says, now the Election Commission of India will have Chief Election Commissioner and not more than 4 election commissioners. Initially, all these individuals, Chief Election Commissioner was given the status of a Supreme Court judge. Election commissioners were given the status of High Court judge. That means more power was given to the Chief Election Commissioner. But this law was amended in 2013 to give same status to election commissioners as the status of the Chief Election Commissioner. That means now Chief Election Commissioner and the election commissioners, they both have the status of the judge of a Supreme Court. And you will have to take the decision unanimously through consensus. If consensus cannot be arrived, then you have to go for the majority. That means voting will take place. Whoever has the majority, that would be the decision. For example, we have Chief Election Commissioner. We have 4 election commissioners. Now they have to decide whether this person should be disqualified or not for holding office of profit. Whether Shinde faction is the real Shiv Sena or Uddhav Thackeray faction is the real Shiv Sena. Ideally, this decision should be taken through consensus. If you can't arrive at a consensus, then you have to go for voting. And whoever has the majority will be the decision. Which means if 3 members say Uddhav Thackeray's faction is the real Shiv Sena, 2 members say no, it is the Shinde faction, that means Election Commission of India will say Uddhav Thackeray faction is the real Shiv Sena. If 2 members say there is 2 leaves, which is the symbol of the AIA DMK, this 2 leaf symbol should be given to Pananiswamy. 3 members say no, this symbol should be given to Paneer Selvam. Then Election Commission of India will say that because of the majority, this symbol will be given to Paneer Selvam. As much as possible, decisions should be taken unanimously through consensus. If not, then by majority. This appointment of 2 election commissioners or 4 election commissioners was challenged by TN Session in the Supreme Court. TN Session himself as the Chief Election Commissioner. When 2 election commissioners were appointed, because the law said that we will have Chief Election Commissioner and not more than 4 election commissioners. And in 1991, two more election commissioners were appointed by the president. Law says not more than four. That means can be less than four. That means two election commissioners were appointed. Even today, we have the chief election commissioner and two election commissioners. Law says cannot be more than four. Can be less than four. Can be three, can be two, can be one. That means when these two election commissioners were appointed, T.N. Session approached the Supreme Court. T.N. Session versus Election Commission of India. The final judgment was given in 1996. T.N. Session said, "My lord, do you know why these two election commissioners are appointed? To clip my powers. Because I am implementing model code of conduct effectively. I am very impartial. I am not partial to any political party. I am implementing the laws of the election vigorously. I don't favor any political party. And now they want to deprive me of implementing these powers vigorously by having two election commissioners appointed by the president. Which means now I will have no say in running the elections. Any decision that I will take, because it is to be taken by the majority, these two election commissioners will say, no, we don't agree. That means if the decision is to be taken through consensus, through majority, ultimately I will be the loser. I cannot implement election laws effectively. So these two election commissioners are not appointed for any other purpose, but just to clip my wings, clip my powers. Supreme Court said, Mr. Session, we agree with you, or we respect you, but we can't do anything in this matter. Why? Because the constitution is clear. The Election Commission of India shall consist of Chief Election Commissioner and as many election commissioners as may be appointed by the president. My dear T.N. Session, this is the job of the executive. This is the prerogative of the executive. Unfortunately, we cannot help you. So now the position remains that we have the Chief Election Commissioner and not more than four election commissioners. We can have less than four. So we have Chief Election Commissioner and two election commissioners. The decisions are to be taken through consensus. If the consensus cannot be arrived at, then by majority. But then let's look at CEC separately, and then we will look at election commissioner separately. What is CEC? Constitution only talks about three things regarding CEC. Just three things. One, appointed by president. Removal in the same manner and on the like grounds as the judge of the Supreme Court. Salary cannot be varied to his disadvantage after the appointment. That's it. Constitution says Chief Election Commissioner shall be appointed by the president and can be removed in the same manner and on the like grounds as the judge of the Supreme Court. What is the manner of the removal of the judge of the Supreme Court? Both Lok Sabha and Rajya Sabha will have to pass a resolution by special majority and then send to the president. President will issue the order. The judge is removed. In the same manner, you have to remove the Chief Election Commissioner. On the same grounds as well. What are the grounds on the basis of which the judge of the Supreme Court is removed? Proved misbehavior or incapacity. Which means the Chief Election Commissioner is appointed by the president and can be removed by the president only on the basis of the resolution passed by both houses of the parliament by special majority on the grounds of proved misbehavior or incapacity. And once you are appointed, your salary cannot be varied to your disadvantage after the election. All this is done, why? To ensure independence of CEC. Once I'm appointed, I cannot be removed. That means I don't hold office during the pleasure of the president. Which means if I will not side with the government, the prime minister will advise the president, dismiss him. That means if I don't have security of tenure, ultimately I will be under the grip of the executive. Which means then I cannot organize free and fair elections. And free and fair election is also part of the basic structure of Indian constitution. So to give my office independence, constitution says you will be appointed by the president, but you cannot be removed by the president on his own. You can be removed just like the judge of the Supreme Court is removed. And once your salary is decided, it is not that just on the eve of your decision, whether Shinde faction or Thackeray faction is the real Shiv Sena, just before that, you are told by the government, if you don't rule in favor of Eknath Shinde, we will reduce your salary. I don't want my salary to be reduced. Nobody would want his salary or her salary to be reduced. I say, don't worry. Shinde is the real Shinde, is the real Shiv Sena. But this cannot happen because your salary, your allowances cannot be varied to your disadvantage after your appointment. But who is this Chief Election Commissioner going to be? What is his term? Can he be reappointed? Can he be appointed somewhere else? Can he join a political party? For that, we have this law, Election Commission of India, Conditions of Service of Election Commissioners Act. And it is this act which says, who is this Chief Election Commissioner going to be? Somebody who is well versed in administration. Constitution says only three things. Chief Election Commissioner appointed by President, removed just like the judge of the Supreme Court. Your salary cannot be varied to your disadvantage after your appointment. But who is the CEC going to be? The law says you should be somebody who is well versed in administration. That means minimum 10 years of experience in administration. And in majority of the cases, IAS officers are appointed as the Chief Election Commissioners. Another incentive for you. Work hard, clear this exam. Over a period of time, you will become the Chief Election Commissioner. And then you will remember this lesson. Your term is 6 years or 65 years, whichever is earlier. For example, my age is 62. That's not my age. For example, my age is 62. I am appointed as the Chief Election Commissioner by the President. For how long will I continue as the Chief Election Commissioner? Either for 6 years or till the age of 65, whichever is earlier. What comes earlier? Me reaching 6 years or me reaching 65 years? 65 years. That means if I'm 62 now, for the next 3 years, I will be the Chief Election Commissioner. After that, my term is over. Even if my normal term is for 6 years. But if I cross the age of 65 before 65 years, if I cross the age of 65 before crossing 6-year term, my term is over. Or should I say, to make it clear to you, if my age right now is 50, I am appointed as the Chief Election Commissioner. What is the retirement age? 65. Will I remain Chief Election Commissioner for the next 15 years till I reach the age of 65? Or will I remain Chief Election Commissioner for 6 years only till the age of 56? I will remain for 6 years. Which means I will remain the Chief Election Commissioner either for 6-year term or till I complete the age of 65, whichever is earlier. Cannot be reappointed as the CEC. Once I'm appointed as the CEC, after my term is over, that means let's say I was 50 until the age of 56, when I complete 6-year tenure, Can I be reappointed as the Chief Election Commissioner? No. Why? Why would I be reappointed? That too by the President. That too on the advice of the Prime Minister and his Council of Ministers, which means I favor them, or I will favor them, or I have a deal with them. Otherwise, why would they reappoint me? To ensure independence of this office. Once your term is over, you cannot be reappointed as the Chief Election Commissioner. Can happen, but only during financial emergency. That means my salary, my allowances cannot be varied to my disadvantage after my appointment, but can be varied to my disadvantage only during financial emergency. This is the Chief Election Commissioner. What about election commissioners? According to this law, election commissioners are appointed by President and shall be removed by the President only on the recommendation of the Chief Election Commissioner. That means this election commissioner does not enjoy security of tenure. Although you hold office till 65 years or 6 years, whichever is earlier, but you can be appointed by the President, you can be removed only on the recommendation of the CEC. That means the protection which is available to Chief Election Commissioner, where he can be removed by the President only in the same manner and on the like grounds as the judge of the Supreme Court, that protection is not available to an election commissioner. Election commissioners are appointed by the President and can be removed only on the recommendation of the CEC. If the CEC says, please remove, the President may remove that election commissioner. But this recommendation is not binding on the President. There was a time when the Chief Election Commissioner recommended to the President that please remove this election commissioner. You don't need to remember the name. It is irrelevant for your exam. Even if you want to, Naveen Chawla is the name of that election commissioner. The CEC alleged and thought that Naveen Chawla is helping the Congress party. He recommended the President, please remove Naveen Chawla as the election commissioner. But this recommendation is not binding on the President. President did not remove. And later on, Naveen Chawla became the Chief Election Commissioner. Whatever it is. The fact is, election commissioners are appointed by the President, can be removed only on the recommendations of the Chief Election Commissioner, and these recommendations are not binding. But these election commissioners, they hold office till 65 years or 6 years, whichever is earlier. Cannot be reappointed as member, but can be appointed as CEC, provided the total term as CEC plus EC does not exceed 6 years. I am appointed as the election commissioner by the President. My term is till the age of 65 or 6 years, whichever is earlier. Once my term is over, can I be reappointed as the member, as the election commissioner? No. But can I be promoted as the Chief Election Commissioner? Yes. Provided the total term My total tenure at the Election Commission does not exceed 6 years, which means I was appointed as the Election Commissioner at the age of 50. When I completed 3 years at the age of 53, my Chief Election Commissioner, his term got over, or he was removed, or he is dead, or he resigned. Then I am promoted as the Chief Election Commissioner. But what is the term of the Chief Election Commissioner? 6 years and 65 years, whichever is earlier. I am 53 right now. Does that mean if I am today appointed as the Chief Election Commissioner, I will continue till I complete the age of 59? That means for another 6 years? Because I've still not completed 65? No. I can continue as the Election Commission only till 1956. Because if I was appointed as the Election Commissioner in 1950, in 1953 I was promoted as the Chief Election Commissioner. Even if the tenure is 6 years, I will continue only for 3 more years till 1956, because my combined tenure at Election Commission as CEC and EC cannot exceed beyond 6 years. Matter went to the court. 5 years ago, Anup Baranwal versus Union of India. This year, the judgment was given. Prashant Bhushan was the lead lawyer in this case. Two important questions were asked to the Supreme Court. Dear Supreme Court, question number one: does the current process of appointments not violate right to equality? That CEC is appointed by the president and removed just like the judge of the Supreme Court. But election commissioners appointed by the president, they are the same power but removed only on the recommendations of the CEC. And the current system of appointment is such that executive has the complete say. Who appoints CEC? President on the advice of Prime Minister. Who appoints election commissioner? President on the recommendations, on the advice of the Prime Minister. Prime Minister, Council of Ministers, they belong to a political party. This political party has to contest the elections. These elections have to be free and fair. Will the individual or individuals appointed by the same political party, their leaders, ensure free and fair elections? Does the current process of appointment not violate free and fair elections, which is also part of the basic structure of the Constitution? Supreme Court said, we regret. This is not something which Constitution wanted. Because Constitution said the president shall appoint the chief election commissioner and the president shall appoint the election commissioners till the time Parliament enacts a law. Just like when we discussed powers, privileges, immunities of legislators, I told you, till the time Parliament enacts a law, all the powers, immunities, privileges which are available to British parliamentarians will apply to Indian parliamentarians as well. But Parliament had to enact a law to define, codify all these parliamentary privileges. Similarly, this was not meant to be forever, that the CEC and election commissioner shall be appointed by the president. The Election Commission of India shall appoint the CEC and as many election commissioners as may be appointed by the president. For that, law had to be passed by the Parliament. This law should have talked about how appointments will be made. It was never meant to be under the exclusive control of the executive, because then you are violating free and fair elections. Then I will appoint that person as the CEC who is going to help me in my elections. And surprisingly, we have seen instances where Mr. M.S. Gill may be a terrific election commissioner, But after his term as the election commissioner got over, he joined the Congress party and became a member of the Rajya Sabha. One more election commissioner, Mr. Ashok Lavasa. He was considered to be very upright. Whether this story is true or not, I don't know, but I'm reading newspapers. So if at all you are offended by this, be offended by the Hindu or the Indian Express, not me, because I'm just quoting them. I don't know. Mr. Ashok Lavasa was considered to be a very honest, upright election commissioner. There were some allegations of violation of model code of conduct by the Prime Minister. Now, Election Commission unanimously has to decide whether Prime Minister was right or wrong, whether he has indeed violated model code of conduct or not. Election Commission said Prime Minister has not violated model code of conduct. It is mentioned in the newspapers that Ashok Lavasa objected, saying, yes, he has clearly violated model code of conduct. And I want to mention it in writing that he has violated this. Although Election Commission has taken a decision which is different, saying, because they have to take the decision by majority, that Prime Minister has not violated model code of conduct. I want to put it on record that he has violated model code of conduct because of these reasons. But because I'm in the minority, I'm only one individual, and the will of the majority prevails. Maybe not acceptable to the Prime Minister or to the ruling party, because the sense that it will give others is that Election Commission is biased in favor of the ruling party. And here is an independent, honest, upright election commissioner who, whatever it takes, is going to defend the Election Commission. Suddenly came newspaper reports. Enforcement Directorate, other organizations are now against the wife and the daughter of Ashok Lavasa, carrying out some investigation, some genuine investigation, whether there is some money laundering or whether the profits of the company are properly distributed, some elements of corruption. Suddenly we realized that Ashok Lavasa has resigned. Ashok Lavasa has resigned and all the cases against his family disappears. Ashok Lavasa has not only resigned, he is now made the president of the Asian Development Bank. And a new election commissioner is appointed. Maybe, I don't know, maybe you resign from the election commission because we can't trust you now. We will drop your cases against your family members. We will also send you as our representative to Asian Development Bank. Everybody is happy. Mr. Ashok Lavasa resigns. New election commissioner is appointed. Maybe this new election commissioner will favor the ruling party. And this is not only for the BJP. BJP is right now in power and we're talking about BJP. Enough has been done by the Congress previously. And enough will be done by the Aam Aadmi Party tomorrow if this system continues. Matter went to the court. Anup Baranwal versus Union of India. Supreme Court said no. We cannot allow this to continue. Law has to be passed by the parliament. Let the parliament enact a law and define how do you appoint CEC and election commissioners. Because Constitution said you have to pass a law. You're not passing that law, that's your problem. But we are saying enough is enough. You have to pass that law. Until the time you pass this law, Chief Election Commissioner, election commissioners will be appointed by President, but after recommendation of a committee. Committee will have Prime Minister, Leader of Opposition in Lok Sabha, or if we don't have a Leader of Opposition in Lok Sabha, then the Leader of the single largest party in Lok Sabha and Your Excellency himself, the Chief Justice of India. I will also be part of that committee. Is this a good judgment or bad judgment? Good in the sense that yes, since Constitution envisaged that there has to be a law which will define how these appointments will take place. Since no such law was passed, that's why we had a situation where executive had complete control over appointments to election commission, which may violate free and fair elections. But it is another matter that despite the same system of appointment, if there is one institution which was respected throughout the country, that was Election Commission of India. So there are very few organizations or institutions in India which were respected throughout Army, for example, UPSC, for example, Election Commission of India. In fact, our Election Commission of India was considered so powerful or so honest and independent that if elections are to be conducted in Myanmar, our election commission used to be the observer. Our election commission would advise the elections in Sri Lanka. Our election commission would advise elections in South Africa, in other African countries. Our EVMs are meant to be copied by other countries. It was the manner in which election commission functioned. And that is thanks to T.N. Seshan, because he governed election commission without any partiality. And now the Supreme Court is saying, which some people say is like judicial overreach, that now President will appoint CEC and election commissioners on the recommendations of a committee. And this committee will consist of Prime Minister, Leader of Opposition, and the Chief Justice of India. Why Chief Justice of India? Why do you want to be part of it? You're part of judiciary, stay there. Or judicial activism. The very presence of the Chief Justice of India will ensure that only good candidates will be selected as the Chief Election Commissioner and election commissioners. But then Parliament got together. Parliament introduced a bill in the Rajya Sabha. Government introduced a bill in Rajya Sabha. And this bill is known as the Chief Election Commissioner and Other Election Commissioners Appointment, Conditions of Service and Term of Office Bill 2023. What this bill does? This bill replaces the 1991 law. This law will be replaced by this bill. Why this bill was introduced? Because Supreme Court, you said you have to pass a law. And now we are passing a law. This bill is now introduced. What this bill says, this Chief Election Commissioner and Election Commissioner will be appointed by the President on the recommendations of a selection committee. Now, the selection committee will consist of Prime Minister, Union Cabinet Minister, Leader of Opposition or Leader of the single largest party in Lok Sabha. That means Chief Justice of India has now been replaced by Union Cabinet, which basically means that we will have a Prime Minister part of the selection committee. We will have Home Minister part of the selection committee, Mr. Amit Shah, and we will have Mr. Adhir Ranjan Chaudhary, who is not the Leader of Opposition, but Leader of the single largest party in Lok Sabha right now. Who will take the decision? That means again the same process. President, the Prime Minister, Home Minister, they will advise the President, please appoint this person as the Chief Election Commissioner. What changes? Nothing. Not just this. Recommendation of the selection committee will be valid even when there is a vacancy in this committee. Adhir Ranjan Chaudhary is kept under house arrest or he is killed. There is a vacancy. Even if there is a vacancy, the recommendations of the selection committee would be valid. That means these two gentlemen will be laughing, Prime Minister and Home Minister. President, here is the recommendation. Appoint this person. What changes? Nothing. A search committee headed by Cabinet Secretary will propose a panel of names to the selection committee. A search panel will be set up, headed by the Cabinet Secretary. It will look out for candidates, those candidates who have experience of more than 10 years in administration, senior IAS officers. And ultimately, a list of names will be presented to this committee. Pick names from this committee. That means I have done my homework. These are the more suitable candidates. Pick a name from this list and appoint that, recommend those names to the President. But the issue here is, this selection committee of Prime Minister, Home Minister and Prime Minister, Cabinet Minister and Leader of Opposition can choose a name even if it is not there in the list. Hard work is done by the Cabinet Secretary. List is prepared. This committee can choose either somebody from this list or someone outside from this list as well. The salary and conditions of CEC and ECs will be equivalent to that of the cabinet secretary. 1991 law said salary of the CEC and election commissioner will be same as that of the judge of a Supreme Court. Now what you're saying, the salary will be equivalent to that of the cabinet secretary. Do you know what you're doing and why you're doing it? Salary of the judges of the Supreme Court is fixed by Parliament. That means Parliament will enact a law and fix the salary of the judges of the Supreme Court. That means in the same manner, you are giving the same salary to the CEC and election commissioner. That means CEC and election commissioner, your salary will be determined by the Parliament because your salary is same as that of the judges of the Supreme Court. Their salary changes, your salary also change. But now your salary is that of the cabinet secretary. But the problem is that the salary of the cabinet secretary is decided by the government. Not by the Parliament, but by the government. Which means CEC and election commissioner, come here. If you don't say, okay sir, I understood. If I don't say that Shinde faction is the real Shiv Sena, not the Thackeray faction, you will reduce my salary, you will change my salary. I understood that. Thackeray faction is not the real Shiv Sena, Shinde faction is the real Shiv Sena. Because now, imagine a constitutional body known as the Election Commission of India, with Chief Election Commissioner and the election commissioners, their salary equivalent to a cabinet secretary, which is not a constitutional post. That's another problem. Election Commission will consist of Chief Election Commissioner and other election commissioners. The president will periodically fix the number of election commissioners. That's okay, because Constitution said Election Commission will consist of CEC and election commissioners and as many election commissioners as the president may by order specify. This can be important for your prelims. Who can increase the number of election commissioners? President, Chief Justice, Parliament, Prime Minister, President. Appointment of the commission. The commission will be appointed by the president upon the recommendations of the selection committee. Selection committee will comprise of Prime Minister, Cabinet Minister, Leader of Opposition. A search committee headed by Cabinet Secretary will suggest 5 names to the selection committee, but the selection committee may consider any other person other than those suggested by the search committee. CEC and election commissioners must be the persons of integrity. They should have knowledge and experience in the management and conduct of elections, or be or have been secretary or equivalent to the government. Maybe the state election commissioner who has experience in holding elections is a man of integrity or a woman of integrity, or has been a secretary to the central government or to the state government. This is your eligibility. You can be appointed as the CEC or election commissioners. All the members will hold office for 6 years or until they attain the age of 65, whichever is earlier. Members cannot be reappointed as members, but if the EC is appointed as CEC, the combined term should not be more than 6 years. The salary, allowances and other conditions of service will be same as that of the cabinet secretary. If I am an IAS officer and now appointed as the chief election commissioner, I will get the pension as well after my retirement. What is that pension? The pension I would have got as an IAS officer. The same pension that you would be entitled to because you were part of a service. The bill retains the manner of removal of CEC and election commissioners as specified in the Constitution, which means the CEC shall be removed in the same way, in the same manner as the judge of the Supreme Court, while the election commissioners will be removed by the president on the recommendations, only on the recommendations of the CEC. That means even now these ECs, they do not have security of tenure. That is what this bill tries to do. This bill is pending in the Rajya Sabha, will be passed by Rajya Sabha, then Lok Sabha, then signed by the president, and ultimately it will go to the court. The court will have to decide whether this law is constitutional or not. Any questions as of now? Can EVMs be hacked? My dear, patience. We will take a look at election process, then we will go to the polling booth, then press the EVM button, and then I will tell you whether your vote has been registered correctly or not. First, let the elections begin. Let the party begins. Okay, let's take a break. We will meet 8:15, and then let's see how far we can go. See you on the other side of the break at 8:15. Bye bye. Now let's look at what are the functions of the Election Commission of India. To advise the president on disqualification petitions. For example, if there is a change in the nature of your citizenship, if you are adjudged insolvent, if you are declared mentally unsound, if you're holding an office of profit, on all these grounds, a legislator can be disqualified by the president if you are a member of the parliament, by the governor if you are the member of the state legislature. But the president and the governor cannot act on their own. They have to act on the recommendations, on the report of the Election Commission of India. So Election Commission of India has the power, has the function to advise the president and the governor on these disqualification petitions. To resolve disputes related to party name and symbol. When there are more than one claimants, there is a split in the political party, let's say the NCP or Shiv Sena or AIADMK or Lok Jan Shakti Party. There are more than one claims. Paneer Selvam claims, I am the real AIADMK, so this symbol should be given to me, this name should be given to me. Eknath Shinde says, I am the real Shiv Sena, the symbol should be given to me, the name should be given to me. Such disputes related to party name, party symbol, when there are more claimants to this, are also decided by Election Commission of India. That's another function. Principal function is superintendence, direction, conduct, control of all the elections, whether it is at the parliament or president, vice president, state legislature. Superintendence, direction, conduct, and control of all these elections is vested with this body known as Election Commission of India. But what is the superintendence, direction, conduct, control? 1961, 1968. Election conduct rules, symbols order was issued by the Election Commission of India. To hold elections, to organize elections, there is law passed by the parliament known as Representation of the People Act 1951. That means if there is a law which governs the entire conduct of elections in India, that law is passed by the parliament because they have the power under Article 327, and that law is Representation of the People Act 1951. But who has the power to superintend and direct, conduct, and control these elections? Election Commission of India. To better implement election laws, rules were made by Election Commission known as Election Conduct Rules and the Symbols Order in 1968, according to which a symbol can be issued to a political party, a symbol can be withdrawn from a political party can be recognized as a national political party, as a state political party. All these rules and orders have been issued by the Election Commission of India. Matter went to the court. The Supreme Court had to decide whether this indeed is the power of the Election Commission of India, or can all these decisions be taken only by the Parliament. This decision, Supreme Court said, all these powers are plenary in character. That means unrestricted by the executive. If the power to the Election Commission, listen to me carefully, if superintendent's direction, conduct and control of all these elections is vested with Election Commission of India, to implement these powers, to make use of these powers, the Election Commission of India can make rules to better control and conduct the elections. And when Election Commission is using these powers cannot be restricted by the executive. These powers cannot be controlled by the executive. The question the court was asked, what do you mean by these plenary powers which are unrestricted by the executive? Supreme Court said, when a law is passed by Parliament, Election Commission of India has to abide by this law, has to follow this law, has to use this law, implement this law. But if this law is silent in a given situation, is insufficient in a given situation, then what Election Commission of India can do, it can make rules. And while making these rules, executive cannot interfere. This case was Kanhaya Lal Umar versus R.K. Trivedi. What Supreme Court is saying? Look at the powers vested with Election Commission of India. Superintendent's direction, conduct, control. When Election Commission of India has to utilize these powers, it will have to look at the law passed by the Parliament, which is Representation of the People Act, and implement it. But if this law is silent in a given situation, if this law is insufficient in a given situation, then Election Commission of India can make rules and executive cannot interfere with these rules. For example, if Representation of the People Act governs the conduct of elections and this law is passed by the Parliament, Election Commission of India said to better control these elections, conduct these elections, we need to assign symbols to the political parties. And we have the power to allot a symbol. We can remove that, withdraw that symbol as well. We can register political parties. We can recognize political parties as either national or state political party, so that we are able to control the elections, conduct the elections in an efficient manner. Supreme Court said this is your right under this provision known as superintendent's direction, conduct and control. When you're making these rules, executive will never interfere, cannot interfere. Something else. A by-election was to be conducted in Parur or Paravarur constituency in Kerala. And this by-election was conducted using electronic voting machine. Elections were held, a candidate won, a candidate lost. The candidate who lost, he approached the Supreme Court, saying this election should be declared null and void. Why? Because Election Commission of India is using EVM. Election Commission of India should have used ballot paper. Why? Because Representation of the People Act 1951 which governs the conduct of elections, it explicitly talks about holding elections through ballot paper. So how can Election Commission of India junk ballot papers, instead use EVMs? This is something that should not be allowed. Election Commission of India told the Supreme Court, dear Supreme Court, you have said that we have superintendent's direction, conduct and control over elections. And for that, we can do anything. These are plenary in character. These powers cannot be restricted by the executive. And we have replaced ballot papers with the EVMs. Supreme Court said this by-election is null and void. Election Commission of India asked why. Supreme Court said Election Commission of India has to follow the law passed by the Parliament. What you can do, you can supplement this law, but what you cannot do, you cannot supplant the law. Election Commission of India asked, I don't understand. What is the difference between supplementing a law and supplanting a law? Supreme Court said if the law is insufficient in a given situation, insufficient or silent in a given situation. For example, the Law Representation of the People Act talks about conduct of elections, but it makes no distinction between a registered political party and a recognized political party. It does not talk about a national political party or a state political party. In that cases, you can make your rules to supplement this law. But you cannot supplant this law by saying ballot papers are replaced by EVMs. Because the law is clear, you have to use ballot papers. If the law was silent, saying election will be conducted by Election Commission of India through a process determined by it, then you could have used EVMs, you could have used ballot papers, you could have used any such process. But since the law is clear, you have to use ballot papers, you have to use it. You can't supplant it and replace ballot papers with EVMs. EVMs can be prescribed only if you amend the Representation of the People Act, which can be done only by the Parliament. So you can supplement a law, but you can't supplant a law. How do you organize elections in an efficient manner? For example, in a district, we have the district collector. Listen to me carefully. We have the district collector. You, me, we are the candidates contesting the elections. I fill my nomination papers, and these nomination papers I have to give to the district collector because he is the returning officer. Who is the returning officer? Who returns the winner. That means election happened in this parliamentary constituency. I submitted my nomination papers to the returning officer, who is the district collector. Once the election is over, this returning officer will give you a certificate of winner. That means this returning officer is returning the winner to the people by giving this certificate. But this returning officer who is returning a winner, if, for example, there comes a point where this returning officer is favoring one political party, is using government machinery to influence the voters to vote for a particular candidate, Election Commission of India has the power to transfer that official to another department and appoint a different district collector to this constituency, to this district. Normally, whose job is to appoint a district collector? State government. Whose job is it to transfer district collector to another district, or to transfer the SP, or to transfer the DGP, or to transfer the chief secretary? That's the job of the state government. But when the election process kicks in, when the elections are being conducted, this power can be used by Election Commission of India. If Election Commission of India feels that there is a particular police officer who is favoring a particular political party, Election Commission of India can transfer that officer. That is what we call election conduct rules. To conduct free and fair elections, rules are made by Election Commission of India. This is where executive cannot interfere, because these powers, superintendence, direction, conduct, control, these are plenary in character, unrestricted by executive. Something happened. What happened? 2001, there were unfortunate riots in Gujarat between Hindus and Muslims. You know what the reason is. And ultimately, there was chaos, there were riots, people were displaced. Mr. Modi was the chief minister. As the chief minister, he advised the governor, please dissolve legislative assembly. Legislative assembly still had its time, still had a tenure. But Mr. Modi advised the governor, please dissolve legislative assembly. Legislative assembly was dissolved. Why? One reason was, since riots have taken place, now two communities have been polarized. There is a polarization in the society. You want to take the benefit, you want to reap the benefit by winning the election, by even better majority. So Mr. Modi thought that let's dissolve the legislative assembly so that Election Commission of India can organize fresh elections. Fresh elections will be conducted. My party will return with an even better majority, with an even thumping majority. Who has the power to organize elections? Election Commission of India. Election Commission of India is not announcing dates, is not holding elections. The chief election commissioner was J.M. Lingdo. Election Commission of India is not holding elections, is not organizing elections. Ultimately, the central government asked the president, dear president, can you use your power? Said, what power? Article 143 of the Constitution. Yes. What is that Article 143? Presidential reference. What do you want me to use this power for? Supreme Court is your advisor. Can you refer this matter to the Supreme Court, asking the report of the Supreme Court on this matter, advice of the Supreme Court on this matter, as to what are the powers of the Election Commission of India? Can Election Commission of India refuse to hold elections when there is no legislative assembly in a particular state, where the legislative assembly has been dissolved? Fresh election has to be conducted, and Election Commission of India is not holding elections. An advice was given to the government that what you can do, you can use Representation of the People Act 1951, Section 15. What is Section 15? Section 14. Under Section 14, President. Under Section 15, Governor. What they can do, they can notify elections. Normally what happens? Election Commission of India announces dates, that on these dates election will take place. And once the dates are announced, over a period of time, the president, if it's a Lok Sabha election, governor, if it's a legislative assembly election, will notify these elections. Will notify these elections and say this is the election schedule. And this election schedule is provided by the Election Commission of India. Advice was given to the government that even if Election Commission of India is adamant that we will not hold elections, what you can do, you can ask the governor under Section 55 to notify the election. Once the election is notified, that means Election Commission of India has no other option but to hold these elections, organize these elections. Matter went to the Supreme Court because the president has used Article 143 presidential reference to ask the Supreme Court to give its views, opinion on this matter. Supreme Court said the same thing. Superintendent's direction, conduct, control. These are the powers given to Election Commission of India. These powers are plenary in character, unrestricted by the executive. Which means president and the governor cannot notify elections without the announcement of dates by the Election Commission of India. Election Commission of India was asked, why are you not holding elections? Election Commission of India said, we have the responsibility to ensure free and fair elections. There has been riots in Gujarat, which had led to displacement of the people. People are living in camps, rescue camps. They may not have their voter ID cards. They may not have any identification card. That means they will not be able to vote in these elections. Unless and until situation stabilizes, these individuals who have migrated to different camps, they will go back to their homes. We will ensure that they will have the voter ID cards through which they can vote in the elections. That's how we can ensure fair elections. Under these circumstances, free and fair election is not possible. That's why we are not holding elections. Supreme Court said you are absolutely right. It is your domain. Executive cannot interfere. But please do one thing. Whenever there is premature dissolution of legislative assembly, hold elections within 6 months. Election Commission of India said we will hold elections within 6 months because there has been a premature dissolution of legislative assembly. But we can also not hold elections within 6 months if there is an act of God. Let's say there is an earthquake, there is a tsunami, there is a hurricane, there is a cyclone. These are all acts of God. Under these circumstances, if the Election Commission of India says we cannot hold elections, that is the prerogative of the Election Commission of India, because it is its job to hold free and fair elections. Long story short, what are the powers and functions of Election Commission of India? Various functions. Major functions are to advise the president and the governor on disqualification petitions, to decide on the party name and symbol when there is a split in a political party and there are more than one claimants to the party name and party symbol, to hold and organize free and fair elections under which it can make rules. But these rules should be to supplement the law, not to supplant the law. These rules should aid, help in the better implementation of this law, should not violate the law itself. That is why when in 1982 in Paravarur constituency, EVMs were used for the first time, court said election is null and void because the Representation of the People Act explicitly talks about using ballot papers, not EVMs. So you can't supplant the law by introducing EVM. Later in 1989, the Representation of the People Act was amended to provide for elections through EVMs. So law had to be amended. Representation of the People Act had to be amended to provide elections through use of EVMs. Till that time, you cannot use EVMs. But all these powers are plenary in character, cannot be restricted by the executive. And president and the governor cannot notify elections without the announcement of dates by Election Commission of India. And when dates are to be announced, in how many phases election will take place, when the counting will take place, when the results are to be declared, who are these officers who will be in charge of conducting these elections, that is all the prerogative of the Election Commission of India. And during this election process, the entire machinery is under the supervision of Election Commission. If Election Commission of India feels that there is a particular state official, central official, police personnel who is assisting one political party as against the other, violating free and fair elections, Election Commission of India, even without consulting the state government, can transfer that officer, can remove that officer from the election duty. That is the power of the Election Commission of India. So as of now, we have understood what are these elections, what are the constitutional provisions regarding elections, what is the composition of Election Commission of India, what are the powers of Election Commission of India, how these election commissioners and chief election commissioner is appointed. Now let's look at the entire election process itself. The first step in the election process is electoral roll. What is an electoral roll? In a particular constituency, who are the voters who are eligible to cast their vote? Who have completed 18 years or above and now they are eligible to exercise their right to vote. This preparation of electoral roll starts. It normally starts 5 to 6 months before the elections. We have to prepare our electoral rolls. And this is where Election Commission of India deals with registrar of deaths and births. That means all those people who have died, their names are struck off from the voter list. All those individuals who have now crossed 18, now their names are added to the voter list. So first step in the election process is the preparation of electoral rolls. Now, once the electoral rolls are prepared, then the dates are announced by Election Commission of India. In a much publicized press conference, we have the chief election commissioner, we have the two election commissioners, they address the media and they announce the dates, that on these dates election would take place to Lok Sabha, or election will take place to these 5 legislative assemblies. And as soon as the dates are announced, model code of conduct comes into the picture. So first process is preparation of electoral rolls. Once the electoral rolls are prepared, that means Election Commission of India is now ready to organize, hold elections. In a much publicized press conference, the CEC and the election commissioners will announce the dates of elections. And as soon as the election dates are announced, model code of conduct comes into the picture. This model code of conduct starts as soon as election dates are announced by the Election Commission of India and shall remain in force till the declaration of results. Sir, CEC and EC have equivalent power. They have similar power, same role, same function, same responsibility. In fact, the decisions are to be taken by consensus. If you cannot arrive at a consensus, then you have to resort to voting. And by majority, we get to know what is the decision of the Election Commission. As soon as the election dates are announced, model code of conduct comes into the picture. What is the validity of model code of conduct? It starts as soon as the election dates are announced and it remains in force till the declaration of results. But what is this model code of conduct? The idea is to ensure level playing field. What is this level playing field? If you are preparing for the civil services examination, can UPSC say that all those who are from North India, they have to only appear in mains and the interview, but people from South India, they have to first appear in prelims, then in mains, and then the personality test? Is this a level playing field? It's not. Can we say, or can the UPSC tomorrow say, that all these candidates who want to be recruited as the IAS officers, they should score 1000 marks? But if you are from, let's say, a particular region or a particular religion, we will give you the start of 100 marks. That means all other caste groups, all other communities, they will start with 0. Then they will have to write answers, get these answers evaluated, and basis these answers, they have to reach to 1000. What if some communities are already provided 100 marks extra? They have to just score 900 more. Is this a level playing field? It's not. Same happens with elections as well. There are various candidates contesting these elections. Now, there is a member of the ruling political party. Who is this member of the ruling political party? Let's say this individual is a minister. And you are not a minister, I am a minister. But we are contesting from the same constituency. To travel to different parts of this constituency, you need vehicles, for which you need money, but you don't have enough money. You don't have enough vehicles from which you can use to ferry your supporters to organize rallies in that constituency. Which means, basis your money, you will decide that if there are 10 areas of my constituency, I can visit only 5 because otherwise I don't have the money. But I am a minister. I don't have to worry about the money. I have the government vehicle. I have the government money. I can go to all the 10 areas of this constituency. All I have to do is I am a minister, I have a car, I will use it. That means the fuel is given by the government, which basically means by the people. Money is provided by the people, and ultimately I can go to all the constituencies and campaign for my elections. Is this a level playing field? No. I am not at a level playing field also because you have to bribe the voter, for which you have to give them money. I will also bribe the voter, but I will not pay from my own pocket. I will pay from the government money. How? I will withdraw money from discretionary grants. I will withdraw money from the public account of state because that is operated through executive action. Consolidated fund of state requires state legislature's approval. Public account of India does not require approval of the state legislature. It's kept at the disposal of the government. So the government will then say that all the ministers I have, take 10 crore rupees each. Go to your constituency and inaugurate hospitals, inaugurate parks, inaugurate schools, and use this money. That means I am bribing the voter. You also are bribing the voter, but you cannot bribe all because you don't have enough money. I can bribe all the voters by promising them hospitals, dispensaries, inaugurating them, but using the government money. Is this a level playing field? It's not. How do we ensure this level playing field? For that, a letter was written by Pandit Nehru to all his ministers before the first Lok Sabha elections. Prime Minister Nehru is writing letter to all ministers that, dear ministers, please do one thing. What? Separate your election work from your official work. That means, as a minister, if you have to visit an area, let's say you have to visit an area to inaugurate a hospital, do that, but don't give an election speech there. If you have to inaugurate a hospital at a district, but your constituency is in another district, don't use the government vehicle to travel to your constituency. Use your own vehicle and mention all your expenditure details separately. Do not mix election work with the official work. Because this idea to separate is to ensure level playing field. There's a question asked by Roger. Can EVMs be hacked? I told you we will discuss later, but the reply given by the subject matter expert is, sir has explained it. I have not explained. Please don't give these misleading replies to students. If EC term was completed, can he be reappointed as CEC? No, because your total term was 6 years. If you have completed your term, which means you have completed 6 years, you cannot be reappointed as the chief election commissioner. You can be appointed as election commissioner provided your total term does not exceed 6 years. Okay. This letter was sent by Pandit Nehru to all the ministers to separate election work from official work to ensure level playing field. Some ministers accepted this, some ministers did not. But over a period of time, Kerala state administration, it took some steps, because in Kerala we saw a lot of violence between the communists and the Congress party. Congress activists or the workers of the Congress party would disrupt the meetings of the Communist Party. Communist Party activists would disrupt the meetings of the Congress Party. Ultimately, Kerala government decided, let's invite all the political parties. Let's do one thing. Let's criticize each other, but let's not attack each other personally. So our personal lives should be separated. You attack us on our policies and programs, on our election manifesto. Let's be civil in our discourse. Let's allow political parties to organize their rallies without other political parties disrupting these rallies. And we are part of the government. We will ensure that we will not use public money to campaign for our candidates. We will separate election work from official work. All the political parties in Kerala accepted this and said voluntarily we will abide by this. And that came to be known as Code of Conduct. So in Kerala, political parties themselves, court did not ask them, law did not ask them, police did not ask them, political parties themselves, they've decided to come together and said enough is enough. We have to ensure level playing field and we will not disrupt each other's rallies. We will make the discourse very civil. We will not attack each other. We will attack each other's policies and programs. We will not involve your personal lives into the election campaigns. And that's how Code of Conduct evolved in Kerala. But something good was done by Election Commission of India. Election Commission of India said, take the example of Kerala. What we can do in Kerala, what political parties can do in Kerala, why can't all the political parties in the rest of the country do the same thing? Election Commission of India circulated a document to all the states before the 1962 elections, telling the states, telling the political parties, let's come together and evolve a code which all of us would follow, which all the political parties will follow, just like what Kerala is following. 1967 elections, 3 states decided to come together: Kerala, West Bengal, and Tamil Nadu. All the political parties which will contest elections in West Bengal, Kerala, and Tamil Nadu, we will abide by this code. Election Commission of India is not asking us to do this. We have volunteered. All the political parties have decided to come together to follow this code. Same what was followed in Kerala. But Tamil Nadu went a step further. Tamil Nadu set up a committee of 7 people from 7 different political parties to see whether every political party is following that code or not. What is that code? Don't disrupt each other's rallies. Don't ask for votes in the name of religion or caste or language. Criticize each other, but on the basis of policies and programs. Don't attack each other's personal lives. Government, when the elections are announced, please ensure that you do not announce any new scheme, any new policy, any new program, because that would be similar to, that would tantamount to bribing the voters. Please ensure level playing field. And 7 representatives from 7 different political parties, a committee was set up to oversee, to look into whether this code is followed or not. And it is this code which later on became Model Code of Conduct, which was basically an appeal to political parties for observance of minimum code of conduct during election propaganda. This code came to be known as Model Code of Conduct. But this was implemented brilliantly, impartially by legendary Chief Election Commissioner T.N. Session. But for that, you need to understand that Model Code of Conduct is not mentioned in any law. Model Code of Conduct is not forced upon the political parties by the Election Commission of India. Model Code of Conduct is a unique document which has been conceptualized by political parties themselves. Political parties voluntarily, they have decided to come together and follow this Model Code of Conduct. And now this Model Code of Conduct, which has been voluntarily created by the political parties themselves, will be implemented by Election Commission of India. Which means if any political party violates this Model Code of Conduct, action will be taken by the Election Commission of India. So first, what is the purpose of Model Code of Conduct? To ensure level playing field. When Model Code of Conduct comes into the picture, when the election dates are announced. As soon as the election dates are announced, model code of conduct comes into the picture and it remains in force till the declaration of results. What is the evolution of model code of conduct? This can also be the question asked in your exam. We can trace the evolution to the letter written by Pandit Nehru to all his ministers to separate your election work from the official work. Then Kerala did something. Political parties in Kerala decided to come together and follow this code. They created this code and they said, we will abide by this code. Kerala, West Bengal, Tamil Nadu, they said all political parties contesting elections in our states, we have to abide by this code. And this code came to be known as Model Code of Conduct. And instead of Kerala, West Bengal, Tamil Nadu implementing this, now it is to be implemented throughout the country in all elections, whether Lok Sabha elections or Legislative Assembly elections. But now, under the leadership of T.N. Seshan, T.N. Seshan said, if Model Code of Conduct is a unique document which has been created voluntarily by political parties themselves, now if any political party violates this, Election Commission of India will take action against that candidate, action against that political party. That's the evolution of Model Code of Conduct. But what are the provisions of Model Code of Conduct? One is the general conduct, which is applicable to all political parties. No party or candidate shall include in any activity which may aggravate existing differences or create mutual hatred or cause tension between different castes and communities, whether religious communities or linguistic communities. That means you are giving a speech. A leader of a political party is giving a speech that we will take revenge. We will ensure that injustices will not be accepted. That community, don't vote for them. That community is responsible why we are in the mess that we are in. We need to boycott them. So basically, you're polarizing the society. This is violation of Model Code of Conduct. Action can be taken by Election Commission of India against you. That is why when Mr. Amit Shah in 2014 elections, he said we will take badla, revenge for the Muzaffarnagar riots which happened in 2013. Election Commission of India quickly sent a notice to Amit Shah. What have you said? Why are you saying this? You're violating Model Code of Conduct. Give me the explanation. Mr. Amit Shah said, I'm sorry, I will not repeat this again. Please don't take action against me. Election Commission of India said, after this, if you do anything else, we will take action against you. Azam Khan also said the same thing. But Azam Khan did not apologize. When Azam Khan did not apologize, Election Commission of India said, from now onwards, you cannot campaign in these elections. Quick action is taken by Election Commission whenever somebody violates Model Code of Conduct. Second, criticize each other, but criticize each other's policies, programs, your election manifesto. You cannot or should not, you should refrain from criticism of the personal life of the candidate. Criticize the Congress party, criticize Rahul Gandhi, but don't criticize him on the ground whether he's married or not married, or whether he is secretly married or not married. Why is he going to Malaysia? Why is he going to other countries? Personal life is separate. Official, professional life or election life is separate. Refrain from it. There should be no appeal. Don't ask for votes in the name of religion or in the name of caste. All the Dalits should vote for us. All the Muslims should vote for us. You can't do that. That would be violation of Model Code of Conduct. You cannot go to temple or mosque or churches to campaign for the elections, which basically means you're using religion to ask people to vote for you. This is not allowed. This is violation of Model Code of Conduct. No law said this. Political parties themselves said, let's abide by this and say we will not use religious temples or mosques for for election campaign. And political parties and candidates shall ensure that their supporters do not break into each other's rallies and disrupt their proceedings, disrupt their election campaigns. Political parties have voluntarily agreed. If somebody would violate this, action will be taken, or action can be taken by the Election Commission of India. But the party in power has more restrictions during this Model Code of Conduct. More restrictions. The party in power, whether at the center or in the state, shall ensure that no cause is given for any complaint that it has used its official position for the purpose of election campaign. You cannot use government vehicles to campaign for the elections. There was a time when elections were announced in one North Indian state, and then the chief minister was not happy was not happy with the dates announced by Election Commission of India. The chief minister came in the state chopper to Delhi and met the election commission and said, "You have to please change the dates because of these reasons." Election Commission of India said, "Number one, we will not agree. Number two, you deposit the money, because the chopper that you have used is a state chopper which you are using for election propaganda, which you are using for election campaign. You're not using for your official work. Deposit that money in the state exchequer." Ministers shall not combine their official visit with electioneering work. Government transport, including official aircrafts, vehicles, machinery, and personnel, shall not be used for the furtherance of the interests of the party in power. You can't use government vehicles, government transport, government choppers, aircrafts for your election campaigns, with the exception of the Prime Minister, because for security reasons, he is allowed to use the state aircraft as well, provided if you're organizing that rally for your election campaign, you have to deposit that money in the government exchequer. Similarly, advertisements in the newspaper. Government has the money, and that money is used to advertise various schemes and say that for these schemes you should vote for us. You can advertise, you can ask for people to vote for them by sending advertisements in newspapers, on television, but don't use government money for them, because you are the custodian of that government money. You are the custodian of that public money. That is something that you can't do. Ministers and other authorities shall not sanction grants payment out of discretionary funds from the time elections are announced by Election Commission. You have money in public account of India, or contingency public account of India, public account of state, contingency fund of India, contingency fund of the state. You cannot withdraw that money during the election period without taking approval of the Election Commission of India, to ensure level playing field. But over a period of time, Election Commission of India, as well as various political parties, they were asking for statutory backing. Statutory backing in the sense, what is this model code of conduct? This is a document created by political parties themselves, and political parties have agreed that we will abide by this code, this model code of conduct. But is model code of conduct mentioned in any law? No. Which means if you violate this model code of conduct, what action can be taken against you? Action can be taken against Election Commission. But any other action? No. Because you can be arrested, you can be prosecuted only if you have violated the law of the land. Model code of conduct is not a law. So even if this law has been, even if model code of conduct has been violated, maximum action can be taken by the Election Commission, but Election Commission cannot prosecute you. What if, for example, no new schemes are to be launched during the model code of conduct? What if the government announces new schemes? What action can you take? If you take an action on the ground that you have violated model code of conduct, but that is not a law, so Election Commission of India thought that we should be given a statutory backing. Model code of conduct should be passed in the form of a law, so that if anybody violates model code of conduct, we can prosecute that individual for violating that law. But over a period of time, Election Commission of India says we are not in favor of statutory backing. Why? Because if statutory backing is given to model code of conduct, the ball lies in the court of judiciary. Which means Azam Khan and Mr. Amit Shah violated Model Code of Conduct. Quick notice was sent by Election Commission of India to them. Tell us why action should not be taken against you. Azam Khan did not apologize, action was taken. Amit Shah apologized, action stopped. But what if this was indeed a law, indeed a statute, Model Code of Conduct? Who can punish for violating a law? Judiciary. That means Azam Khan violating Model Code of Conduct, Amit Shah violating Model Code of Conduct. Instead of Election Commission of India deciding on this matter will be taken to judiciary. And we know judiciary is a slow poison. It will take decision when the granddaughter of Amit Shah will be able to contest the elections or is contesting the elections. That means it will take time after time, tariq pe tariq pe tariq. That means you are violating the election atmosphere. You go away with that because the election is over, results are declared, and now court will decide whether you were guilty of violating Model Code of Conduct or not. That is why now Election Commission of India says we are not in favor of giving legal status or statutory backing to Model Code of Conduct. Because if it is given statutory backing, it becomes a law. Then we can't implement this. Violating this law would come under the domain of the judiciary, and judiciary will take action after the entire election is over. That means Model Code of Conduct would not become efficient. And Election Commission of India has realized that some of the provisions that are mentioned in Model Code of Conduct are already present in some other laws. For example, Model Code of Conduct says you can't bribe a voter. Bribing is a crime under Indian Penal Code. Model Code of Conduct says you cannot ask for votes in the name of religion or caste. But that is also violation of Representation of the People Act, because RPA 1951 also says you cannot ask for votes in the name of religion or caste or language. Model Code of Conduct says you cannot, under any circumstance, give a speech which will aggravate the distance between the two communities or polarize the communities. If you do that, you're violating Model Code of Conduct. But if you give the speech, it is also hate speech under Indian Penal Code. So there are some provisions in the Model Code of Conduct which are similar to some provisions in Indian Penal Code, some provisions in Representation of the People Act. Then what will we do? This is a better deadly combo. Combo in the sense, if somebody is asking for votes in the name of religion, or if somebody is giving a speech, a hate speech, which tries to polarize the two communities, first action will be taken by Election Commission of India that from now onwards you cannot campaign in these elections. When you cannot campaign, it basically means you cannot reach out to more voters asking for their votes, which means you are at a loss because you may end up losing the elections. And once you are banned from from campaigning in these elections, then we will also file an FIR in the police saying you are giving a speech which is hate speech. And then after the election is over, judiciary will take action against you and will send you behind bars. So Model Code of Conduct has emerged as a document which ensures the sanctity of the elections, which also ensures level playing field. Election Commission of India is not in favor of giving a legal status or a statutory backing to Model Code of Conduct, because as it would mean that the power to enforce it will go away from Election Commission of India to the Supreme Court or to the judiciary. And this Model Code of Conduct has been beautifully explained by former Chief Election Commissioner S.Y. Qureshi, who writes in his book, Elections and Undocumented Wonder. In this book, Dr. S.Y. Qureshi writes that there came a time when in Goa, Shri Manohar Parrikar was the chief minister. Elections were announced. Model Code of Conduct was in picture. And then Mr. Manohar Parrikar chose one person to become a minister. He recommended the name of this individual to be appointed as the minister under the Goa government. S.V. Qureshi says, I dialed Manohar Parrikar and I told him, don't do this. This would be violation of Model Code of Conduct. He says that Mr. Manohar Parrikar was furious. How can you say it violates Model Code of Conduct? I am a constitutional functionary. I am the chief minister. I have the responsibility to advise to the governor about my ministers. I can recommend anybody to the governor to be made a minister. This is my constitutional right. How can you snatch this constitutional right? S.V. Qureshi says, I told him that this candidate whom you are appointing as a minister is not a minister right now. He is not the member as well, but he is contesting elections from a constituency. And there you have other candidates contesting elections as well. If suddenly you are appointing this person as the minister, then it won't be a level playing field. If he was a minister previously, that's okay. Now during Model Code of Conduct, if you appoint him as a minister, it will disturb level playing field. S.V. Qureshi says, Mr. Manohar Parrikar agreed to this, accepted this, understood this, and said, I bow down before this Model Code of Conduct. I give up my constitutional right to choose a minister before the Model Code of Conduct. In another instance, there was a law minister who announced a scheme when Model Code of Conduct was into the picture. Mr. S.V. Qureshi says, I asked that minister, don't do this. He said, I'll still go ahead and do it. Chief Election Commissioner approached the president. President censured that minister, saying you should not have violated Model Code of Conduct. And ultimately, that candidate, that minister, lost the election. So the sanction of Model Code of Conduct may not be law. Model Code of Conduct may not have legal sanction, but it has political sanction. And whenever newspapers would publish details of those who violate Model Code of Conduct, people don't take such candidates seriously. They vote them out. But over a period of time, we have seen Model Code of Conduct being violated. Whether it is Lok Sabha elections in 2019, whether it is the Delhi Assembly elections in 2020, right now at least we are seeing lesser number of violations of Model Code of Conduct. For example, Mr. Modi, in 2019 elections, he said Rahul Baba is contesting elections from a constituency where majority is in minority. So basically he is alleging that Rahul Gandhi chose Wayanad constituency where majority, which is Hindus, are in the minority. Basically giving a speech saying something which will polarize the society. Isn't this Model Code of Conduct violation? Political parties approached Election Commission. Election Commission said, no, this is not the violation of Model Code of Conduct. Rahul Gandhi said, Prime Minister Modi is chokidar, chokidar chor hai. How can you use this language against the Prime Minister? We said in Model Code of Conduct, you attack each other's policies and programs, but don't hit below the belt. Matter went to Election Commission. Election Commission said, if we cannot take action against Prime Minister, we can't take action against Rahul Gandhi as well. Rahul Gandhi also has not violated Model Code of Conduct. Mr. Anurag Thakur, Information and Broadcasting Minister. Mr. Parvez Sahib Singh Verma went to Delhi, campaigned in these elections, and said, whoever is the traitor of this nation, he should be fired a bullet. Basically giving a speech which aggravates the tensions in the society. It's basically incitement to violence, which is not only violation of Model Code of Conduct, but violation of Indian Penal Code as well. You can't incite people to violence. The only action the Election Commission of India could take was to ban Anurag Thakur and Parvez Sahib Singh Verma from campaigning in Delhi. But by then the damage was already done. That is why there are experts who say that Model Code of Conduct, its implementation has been weak by Election Commission of India. Previously, it was strongly, impartially implemented because we had a strong Chief Election Commissioner who did not bow down to the executive. Now our election commissioners or Chief Election Commissioner Since the complete appointment is with the executive, they are unable to effectively implement model code of conduct. So the best way to implement model code of conduct would be to have an independent election commission of India, which the judgment of the Supreme Court tried to do, which the parliamentary bill is trying to undo by having this committee headed by Prime Minister, Cabinet Minister, and Leader of Opposition. By having this committee to say, even if there is vacancy in this committee, recommendation can be still sent to the President. That is model code of conduct. Any questions? Did Srimati Sonia Gandhi's use of DD national platform to seek votes not constitute a violation of model code of conduct in 2014? No, it does not, because all the political parties, particularly recognized political parties, which we will discuss who are these recognized political parties, they are given free airtime on Doordarshan as well as All India Radio, where they can campaign for their elections. And that is free of cost given to recognized political parties. Common people can criticize, yes. Now there is Vikshit Bharat Sankalp Yatra, which the government tried to introduce, wherein if there are defense personnel who are on leave, government officers, they have to go to the people to popularize the various schemes of the government. But Election Commission of India said, don't do this during model code of conduct, and the government agrees. That means quick action can be taken in case model code of conduct is violated. All you need to have is a strong chief election commissioner and the election commissioners. They don't have to wait for judiciary. They will take a decision now and quickly it will be implemented. But election commission does not have the power to de-recognize a political party. It does not have the power to disqualify a candidate for contesting the elections if this candidate has violated the model code of conduct. So better solution can be model code of conduct should be modified to allow Election Commission of India to cancel the candidature in case of MCC violation. Sir, when Rahul Gandhi said Modi chor hai, was that against MCC? Then why the statement is against all Modi? No, that statement was given by Mr. Rahul Gandhi at Kolar in Karnataka, wherein he said, why is it that all thieves have the same surname, which is Modi? Whether it is Nirav Modi or, according to him, Mr. Modi or Lalit Modi. Then there was an individual who filed a defamation complaint, criminal defamation, saying, I also belong to the Modi caste group. You have defamed me. And ultimately, Modi as a class was declared by the Gujarat court, saying the entire caste group or the entire class was defamed by Rahul Gandhi. And as such, he was declared guilty of criminal contempt, criminal defamation. Okay. Now, as soon as first electoral rolls are prepared, then dates are announced by the Election Commission of India. Then, as soon as the dates are announced, model code of conduct comes into the picture. And now we see a process where political parties are campaigning, where there are various demonstrations, so on and so forth. campaigns are going on. And now we come to the voting day. This is when the people will have the right to vote, because today is the voting day. But before that, there is something known as election silence. What is election silence? 48 hours prior to the end of polling is known as the period of election silence. That means throughout this election campaign, people will come out in large numbers. They will attend the rallies of political parties. Political parties will go door to door, try to convince voters to vote for them, their political party. But now this has to end at some point. Why? Because now you have to give opportunity to the people to close their eyes and decide and evaluate who is the best candidate. Across all the candidates who came to us, who is the best candidate, so that I can decide for which political party I need to vote for. In this period of election silence, no election campaign can take place. If today is the voting day, polling day, it ends at 6 p.m. 6 p.m. backwards to 48 hours. That's the period of election silence. During this period of election silence, no election campaign can take place, no rallies can take place, no asking for votes can take place. That is the period of election silence. And now let's come to the voting day. And voting takes place through what we call electronic voting machines. Any voting system that we use, whether we use ballot paper or EVM or tomorrow any other system we use, it must meet four characteristics. It should have four qualities, or it should be having four important ingredients. One, it should be accurate. That means when I'm voting for a particular political party, I should also have this clarity. I should have this lack of fear that if I'm pressing the button in favor of Mr. Modi, it should go to Mr. Modi. It should not go to Mr. Rahul Gandhi. Otherwise, what is the value of my vote? Nothing, zero. I want to hold the government accountable, or I want to re-elect the government. For that, any voting system that I use must be accurate. That means the goal of any voting system is to establish the intent of each individual voter and translate those intent into a final tally. Second, it should be anonymous. I should press the voting ballot, or I should press the ballot, or should drop the ballot paper in such a manner that nobody comes to know who is voting for whom. Because then it can have ramifications for me. If, for example, I voted for candidate A, but candidate B got elected, if candidate B gets to know that this person did not vote for me, tomorrow when I go to him for my complaint, he will not address my complaint. He will victimize me, or he will ensure that my locality also is penalized and punished. This locality, they don't vote for us. We will not take care of their responsibilities. That is why any voting system that you use, first, it should be accurate. Second, it should ensure anonymity so that nobody except the voter gets to know who this person has voted for. And third, it should be scalable as well. It should be able to cater to a massive population, because our population keeps on increasing. We are the most populous country of the world. And it should also be full of speed. That means you should be able to ensure voting takes place quickly and the counting also takes place quickly, so that the results are also declared quickly. Any voting system that we use, whether ballot paper or EVM, must satisfy these four characteristics. Previously, we were using ballot paper, and now we are using electronic voting machines. What are these EVMs? What are their advantages? What are their disadvantages? If the opposition says we should go to back to ballot paper, should we? Can EVMs be hacked? Let's discuss all these questions one by one. These EVMs, I told you, first used in 1982. in a by-election to Parur constituency in Kerala. 1989 Representation of the People Act was amended. It provided for elections through EVMs. Initially, we were using EVMs in some constituencies, not in the entire country. But over a period of time, we have now started using EVMs only. That means when it comes to Lok Sabha election, Legislative Assembly election, we use only the EVMs. In the Rajya Sabha election, because it is single transferable vote system, we don't use EVM. For president, vice president, we don't use EVM, we use ballot paper. But when it comes to Lok Sabha, when it comes to Legislative Assembly, we use EVMs only in all the constituencies throughout the country. These EVMs are manufactured by two public sector undertakings. One is in Bengaluru, the other is in Hyderabad. One Electronics Corporation of India Limited, the other Bharat Electronics Limited. That means there are two public sector undertakings which manufacture these EVMs in association with Election Commission of India. And it has got some advantages. What are these advantages? Advantage number one, speed. There was a time when, imagine a situation, there is a polling booth. There's a long queue of voters waiting to cast their vote. I also want to cast my vote, but I see this long queue. I will not stand in the queue. I will go back home, because who would wait to cast their vote? But what if I know that this long queue will finish off in 10 minutes, 15 minutes? I can wait 15 minutes and I will get my turn in 15 minutes. I will cast my vote and then go. EVMs bring this speed, because when you go, you press the button, you move out of the polling booth. It is not like that previous era where you were provided a ballot paper. In that ballot paper, you had to give your vote, mark your preference, and then go to the compartment, drop the ballot paper in the ballot box, and then go. It was time consuming. Now it is full of speed. Not just the speed in terms of voting, but in terms of counting as well. There was a time previously during ballot paper era when the final results would take 2 to 3 days to be declared, because all these ballot papers are now to be counted manually, one by one, by the people who are part of the exercise. It will take a lot of time to count these votes. Now, when you use EVMs, you press the button, and once these EVMs are to be counted, you just have to press another button and it will give you the count. That for this candidate, these many votes, this candidate, these many votes were polled. You don't have to manually count the votes. It is full of speed, both in terms of voting as well as counting. Second, it is environment friendly. Use of ballot papers would involve use of paper, which involves destruction of trees, which involves destruction of our ecological balance. It's not environmentally friendly. But you use EVMs, it is environmental friendly. Third, booth capturing is the thing of the past. What is this booth capturing? Used to happen in Bihar, UP as well, to a lot of extent. This is the polling booth. I am the presiding officer. Who is the presiding officer? A government employee who has been tasked by Election Commission of India, hold elections. That means for every polling booth, there is a presiding officer. As a voter, you will come inside. I will give you a ballot paper. I will ask you, show me your voter ID card. Yes, your name is mentioned in the voter list. Now take this ballot paper, go to the voting compartment. You will go to the voting compartment. You will make your preference, mark your preference. You will say, I will mark tick against the candidate of the BJP. Then I will drop this ballot paper in the ballot box, and then I go. What also used to happen, I am the presiding officer. And now the gundas, the criminals, they are entering the polling booth. Hands up, presiding officer, give the ballot papers to us, otherwise we will shoot you. Why would I lose my life? Take these ballot papers. And these ballot papers were taken by these gundas. Preference was given. They were stamped using the stamp of the presiding officer, dropped in the ballot box. Problem solved. This is what we call booth capturing, where gundas, they capture the booth. They vote on behalf of others, but they will vote for their own candidate. That means fair election could not take place. Or there was multiple other instances where if the voting in this polling booth is over and I get to know that people in this polling booth did not vote for me, because I have my agents everywhere. They do talk to people. Who are you voting for? Okay, these people are from that particular caste, but my candidate is from a different caste. These people are from different religion, but my candidate is from a different religion, so they will not vote. When they will go inside the polling booth, vote, then the gundas will come, will pour ink inside the ballot box, which makes all the votes redundant. Booth capturing. But now this booth capturing cannot happen and does not happen. Why? There is a control unit and there is a ballot unit. This control unit and ballot unit is separated by a 5-meter cable. Control unit is with the presiding officer. Ballot unit is inside the voting compartment, which means you enter the polling booth, you show the voter ID card, you are verified. Now go to the voting compartment, press the button, and then go. What if the gunda comes? As soon as I see that gunda is coming, because he will create ruckus outside, people outside will try to stop him, but now he's unable to be stopped and he will come with the AK-47 and try to kill me. I will press stop button on the ballot control unit. When I press stop button, now no vote can be registered on the EVM. That means booth capturing cannot take place as soon as the presiding officer presses the stop button. But what if this presiding officer fails to press the control stop button and this gunda is aiming with the AK-47? He will go to the voting compartment, the gunda, and will start pressing the button. 1, 2, 3, 4, 5, and now the EVM will be jammed. Because you can only vote 5 times in a minute. That's the limit. Because it will take at least some seconds for one voter to come, show the voter ID card, and then press the button and then go. It will take some time. So to calculate that time, the programming of EVM is such that it will take only 5 votes per minute, which means the gunda comes, presses the EVM 5 times, 1, 2, 3, 4, 5. Then he has to wait for 55 seconds. Till that time, there will be police which will come, arrest this individual. Booth capturing cannot take place. Another important advantage of EVM is that invalid votes are also the thing of the past. What are these invalid votes? This is the ballot paper, for example. These are the candidates A, B, C, D, E. But I'm an illiterate person. I entered the polling booth. I gave my voter ID card. It was verified. Then ballot paper was given. Please go there, mark your preference, and then drop it in the ballot box. I mark it like this. Although ballot papers are not like this, but I'm just giving you for the sake of explanation. And then I give my preference. I vote in favor of a candidate. I drop it in the ballot box. And now once these votes are to be counted, we will have to count these ballot papers one by one. And when this ballot paper will be shown to me, is this vote for B or C? I don't know. can be B, can be C. So this vote is invalid. Sometimes what happens, and what used to happen, is that candidate A got 10,000 votes, candidate B got 9,800 votes, and others got less than this. Who is the candidate from your constituency? Who is the winner from your constituency? Candidate A. But from this constituency, when we take into account invalid votes can be 3,000. That means invalid votes in some areas used to be more than the difference between the winner and the loser. These 3,000 votes would have gone to anywhere. Maybe it would have been to candidate C, who got 9,000 votes. So now this candidate C is at serial number 3, but ideally he should have been at serial number 1, because the people who voted for him, they could not mark it correctly. The number of invalid votes sometimes used to be more than the difference between the winner and the loser. But now in EVM, there is no invalid vote. You go inside, press the button, it will be registered in favor of the candidate. Whether it will be registered for the candidate you wanted to choose, that's another matter which we will discuss, but it will go only to one candidate. There is no such thing as invalid vote. All these are the advantages of electronic voting machines. Even then, there are people who say EVMs should not continue, EVMs can be hacked. England and France, they have never used EVMs. United States, for example, in some states they use EVMs, but in majority of the states they don't use. Italy spent millions of dollars on EVMs to manufacture EVMs, but ultimately shelved the idea, saying we don't want it. Same was done by Netherlands. Spent a lot of money to manufacture an EVM, but after that they said no. In Germany, EVMs were declared unconstitutional. If in Germany EVMs are unconstitutional, if England and France have never used it, if Netherlands has, after spending millions of dollars, shelved that idea, if US uses it in some states and not in others, why is India using it? Are our EVMs so technologically advanced, so secure, so accurate? Perhaps yes. Why? Because our EVMs do not contain a transmitter and receiver. When in an EVM there is no transmitter, no receiver, that means cannot be connected to internet. When it cannot be connected to internet, means it cannot be hacked. Because what is the definition of hacking? If your EVM is remotely operated, your phone can be hacked because somebody remotely has access to your phone, to your computer. That is possible because your phone, your computer is connected to internet, and through internet it can be remotely operated. EVMs, they have no transmitter, no receiver, which means they cannot be connected to internet, which means they cannot be hacked. In fact, EVMs, the software is built and burnt once. That means once the code is written, the software code is written, this software code is just like the calculator. What is the role of the calculator? 1 plus 7 is equal to 8. 8 plus 2 is equal to 10. That's the role of the calculator. Same software code is similar, is used in the similar software code is used in the EVMs. But once that code is used, it's burned only once. That means now it cannot be rewritten. That means once EVMs were manufactured by two public sector undertakings, then these EVMs are given to Election Commission of India, use these EVMs for elections. After manufacturing these EVMs, the code cannot be changed. Software is used and burned only once. It's like a calculator. Have you ever, for God's sake, heard somebody telling that my calculator has been hacked? My phone has been hacked, you can hear it. My laptop, my desktop has been hacked, you can hear it. My account has been hacked, you can hear it. But have you heard my calculator has been hacked? No, because it is an adder. It just adds. It's not connected to the internet. But even then, if the software is built and burnt only once, what if the software is favoring the ruling political party? Very difficult. Why difficult? Because if this is the AVM, the names on EVM are arranged in alphabetical order. First, national political parties, then state political parties, then registered political parties, then independents. What does that mean? On the electronic voting machine, you have the name of the candidate, you have the symbol of the candidate, and you have the button which you need to press. Take a look at your name, the candidate you want to vote for, check his symbol or her symbol, press the button, and the vote is registered. If software which has been used can be hacked, because software can be hacked, if software can be used, you need a different software to run on electronic voting machines. For that, how would the software look like? If vote is for serial number 1, register in favor of serial number 2. That's how you can do it. That's how programming is. If this, else this. If this, else that. If and else, that is what is used in software programming. Very simple programming. But how do you know if, for example, BJP wants to do this and wants all these software engineers to say, whoever votes for BJP, whoever votes for any other candidate, but this vote should go for the BJP's candidate. How will they be able to factor this? Because in some constituencies, the candidate of the BJP will be at serial number 1. The candidate of the BJP can be at serial number 7. The candidate of the BJP can be at serial number 5. Because all the names on the EVMs are arranged in alphabetical order. First, the names of candidates belonging to national political parties, then belonging to the state political parties, then registered political parties, then independents. And towards the end, there is another option, nota, none of the above. If you don't want to vote for any of the candidates contesting the election, you can press the nota. Plus, when these EVMs are given to Election Commission of India, Election Commission of India opens it in presence of the political parties' representatives. See, this is the EVM that we are going to use for the election. Let's do a test run. All the representatives of political parties will be present. Now you please vote. Let's vote for each other or any other candidate. And then let's count these votes and see if there is any mismatch. Once all of them agree that no, there is no mismatch, then this EVM is sent to a polling booth. And even the Election Commission of India will not come to know who will get this, which polling booth will be given this EVM. Because the code is mentioned in every EVM, and randomly these EVM machines are sent to different locations, different constituencies. So it is impossible to hack these EVMs, and it is not possible to tamper with the software. So EVMs are safe. Mr. Kejriwal said, one of my representatives, one of my party members, he contested elections uh, from Mumbai. And when the votes were counted, he got zero votes, which means EVMs are hacked. Which means all the votes, even if you vote for Aam Aadmi Party or Congress, the vote will go to the BJP. This candidate was asked, what's your take on this matter? He said, let's agree that every voter is a Modi Bhakt, votes for Mr. Modi. But at least my family voted for me. Where is my vote? When the EVMs were counted, the votes in my favor were zero. Forget about that. Even if my family secretly, they are Modi Bucks, they voted for him. But what about me? I voted for myself. Where is that vote? At least I should have got one vote. Where is that vote? That means EVMs are hacked. Mr. Modi is a dictator. This person is lying. There's no better word to use here. Maybe deliberately to cast aspersion on EVMs, he would have voted for someone else. So that tomorrow you can tell, because it's an easy story to sell. I voted for myself. Where is my vote? I got zero. EVMs cannot be hacked. These are safe. But why in Germany EVMs are declared unconstitutional? Because it's not transparent. Not transparent in the sense, when I enter the polling booth, I press the button. The vote is registered. But how do I know whether this vote has been indeed registered to the candidate of my choice, or this vote was registered in favor of someone else? I would never know. So, as a candidate contesting the election, as a voter candidate voting in these elections, I don't know whether my vote has been indeed registered for my political party or not. That is why, because of lack of transparency in Germany, EVMs were declared unconstitutional. And there were problems with EVMs in India as well. I would press the button, but I would not know to whom this vote has been registered. Now, even this problem has been resolved. How this problem has been resolved? Because EVMs are now linked with VVPAT. What is VVPAT? Voter Verifiable Paper Audit Trail, which was used for the first time at Noxon constituency in Nagaland in 2014. What is this VVPAT? EVM will be connected to this VVPAT. As soon as you press the button on the EVM, for 7 seconds, some information will be displayed on VVPAT. What is that information? Serial number of your vote, name of the candidate, symbol of the political party. That means as soon as you press the button on the electronic voting machine, if you were the first voter, but serial number says 32, that means there were 31 votes already stored there. I will raise a flag, because in this polling booth, outside the polling booth, there will be representatives of candidates as well. I'll tell them I was serial number 1, but there are 31 votes already there. One member from the election commission will visit and say, no, this EVM we will not use. Let's bring in another EVM. And then what is the name of the candidate? What is the symbol of the candidate? And once all this information is displayed for 7 seconds, then the slip is cut. It drops into the ballot box. And then what Election Commission of India does, it picks these VVPAT boxes randomly. Randomly in the sense, EVMs have been counted. It shows candidate A got 10,000, candidate B got 5,000, candidate C got 3,000. Let's randomly pick some polling booths some VVPATs, and match these ballot papers with the EVMs to see if there is a complete match. That is how you can be sure about the vote, that you have indeed registered your vote in favor of your candidate. But we have seen some instances VVPATs have malfunctioned. EVMs sometimes may not function. A calculator may stop functioning. We will bring in another EVM, but EVMs cannot be hacked. But we have seen VVPATs malfunctioning. Malfunctioning means VVPAT is like a printer. Sometimes your printer jams. We saw in UP assembly elections, because of extreme heat, sometimes VVPAT stopped functioning. But VVPAT is an important tool, although not environmentally friendly, because we are using ballot papers now, even in VVPAT. But it's an important tool to ensure that your vote has indeed been registered in favor of the candidate of your choice. That is electronic voting machine. But even then, there is one problem which we haven't been able to resolve yet. This can be asked in your mains examination. EVMs violate voter secrecy, or should we say gives away the anonymity of the vote. What do we mean by anonymity? You have voted for a candidate of your choice, but you should not reveal it to anybody. Even if you are revealing it to anybody, but that you are doing it voluntarily. Others should not come to know whom are you voting for or who have you voted for, because you have to have anonymity in the entire election process. And we used to ensure these anonymity during the era of ballot papers. Voter enters the polling booth, gives preference on the ballot paper, drops ballot paper in the ballot box, and then all these ballot boxes are to be taken to the counting center. And in the counting center, these ballot papers are to be voted upon. Now, how these were to be voted upon? If this is a constituency, there may be 10 polling booths from this constituency. Polling booths are spread across throughout the constituency, so that you don't have to travel more than 2 kilometers to cast your vote. If I'm making it difficult for you to go to a polling booth, you will not come to the polling booth, which means entirely the voting percentage would be reduced. It is the job of the Election Commission to ensure massive participation of the people in the voting. That is why Election Commission of India sets up polling booths at convenient locations, less distance between the two polling booths, so that you can cast your vote. And in a particular polling booth, there won't be more than 2,000 voters. That means from this polling booth, one ballot box. From these 20 polling booths in this constituency, 20 ballot boxes. And now all these ballot boxes are emptied into a drum, a big drum where 20 ballot boxes are dropped, their papers are dropped, and then they are mixed. And then one by one, they are counted. Why? Because we will never get to know this vote is from which polling booth. Because if I get to know this vote is from this polling booth, I will get to know this polling booth is voting for whom. And the candidate will get to know whom to support, whose problems to solve, whose grievances to address. Because the candidate will get to know which area from his constituency are his supporters and which area of his constituency are against him. That is why all these ballot papers dropped into the big drum, mixed, and one by one it is counted, and nobody gets to know this vote is from which polling booth. But now we are using EVM. Instead of one ballot box, we have one EVM per polling booth. Now we are taking these 20 EVM machines to the counting center. And then what we do? We count these votes EVM by EVM. And if this is the counting center, what if I will make some mistake? What will 10,000 people say we are voting for the Congress? We have voted for the Congress. I say no, 10,000 people have voted for the BJP. Somebody should be there to check. That is why in this counting center, there will be either the candidate himself or representative of the candidate. That means in this constituency, all the candidates contesting the election will visit, or their representatives will visit. They will keep a track whether somebody is doing anything fishy or not. And now all of them are witness, and I take one EVM. I press the button, it gives me a count. And now on top, there is a screen which displays that after round one, candidate 1 got 100 votes, candidate B got 20 votes, candidate C got 10 votes. And if I'm the candidate, I know exactly from my polling booth, from that location, who voted for me, who voted against. So EVMs, in their use, they violate the secrecy of the voters. They give away the anonymity of the voters. What is the solution? The solution is totalizer. What is a totalizer? It's like an adder. That means just like we had the drum in ballot paper era, where all the ballot boxes were emptied into the drum and then mixed so that one by one we can count the votes. This is the same drum. So this is like an summation, adder. All the EVMs will be linked to this totalizer so that when all EVMs are connected to this totalizer, then a button is pressed on the totalizer, it will give the final number after adding all the other EVMs. That means all EVMs will be added, all EVMs will be connected to this totalizer machine. Totalizer will give you the final amount, final number, that candidate A got these many votes after adding all the EVMs without the candidate, without telling the candidate which area of the polling booth is voting for you and which is against. And totalizers will be able to ensure the secrecy of the vote and ensure the anonymity of the voter. And this totalizer should be implemented. Political parties are against totalizers. Why? Because political parties say it is very important for us in our booth management. Booth management in the sense, if I know that I am weak in one part of my constituency, I will spend more time visiting that part of the constituency and convince them that please vote for me. Or my supporters, they will ensure that they will bring these people to the polling booth. If this polling booth are my supporters, they've been voting for me consistently. That means I have to spend less time here, maybe. Or if people from this polling booth are not going to the polling booth for votes, I will ask my candidates, I will ask my representatives, please help them. Go there and try and convince them to go to the polling booth. This is what we call booth management. If totalizers are implemented, political parties will never come to know which area of the constituency are your supporters and which are against. So you will not be able to practice something called booth management. But for the sake of free and fair elections, we need totalizers to be implemented, and Election Commission of India is in favor of implementing totalizers. Any questions as of now? Seema, what's your question, please? Okay. If, for example, this is an EVM, at the end we have nota. This was asked by the Supreme Court, that Election Commission of India was directed, please provide one button at the bottom of the electronic voting machine, nota. There are less and less voters are not voting in large numbers. Voting percentage is less in India, particularly in urban areas. One reason for that was, it was thought that since these political parties set up candidates with criminal record, they set up candidates who are accused of various crimes. That is why voters don't feel like going out and voting, because who are they going to vote for? These criminals? That's why they don't vote, they disengage from the system. How can we slap these political parties and force them to set up clean candidates contesting the election? If all these political parties are setting up criminal candidates, people can still come out and vote in favor of Nota. That means we don't agree with any of the above. None of these options make any sense to us. Political parties will be embarrassed that look, our candidates have been rejected by the people. For that, the Supreme Court said Nota option should be provided in the electronic voting machine. But this Nota has not been used much. In some states, it is used better, but it is still not effective enough. People are voting for candidates, but they are not pressing the Nota button enough. But there was a petition before the court. What if candidate A gets 10,000 votes, candidate B gets 9,700 votes, and Nota gets 11,000 votes? Who will be the winner from this constituency? The winner will be still A. That means even if Nota gets the highest number of votes, the election would be still won by the candidate who gets the second highest number of votes. In fact, a petition was filed in the court. Supreme Court was told that if there is a constituency where the Nota votes are highest, for that constituency, re-election should be held. Supreme Court said re-election in this situation would be costly. And that is why we should not and we cannot order re-election in case Nota votes are highest. Seema, what's your question? Sir, VVPAT will be installed with all EVMs. Then how is it environmentally friendly? It is still environmentally friendly because we don't use VVPATs in all the constituencies. Now there is a demand by political parties that VVPAT should be used in all the constituencies, in all the polling booths. Why do we not use EVM in presidential election? Because in presidential election, you have to give preference. And our EVMs are not designed to capture preferences. Our EVMs are just like calculators. For Congress, how many votes? For BJP, how many votes? For communists, how many vote? And then give the final amount, final account. Sir, what is Achar Sanhita, which continues during election? Model code of conduct. That is Achar Sanhita. Is totalizer right in your opinion? In my opinion, yes. What is model code of conduct? I don't know. We discussed the entire model code of conduct, my dear. Either you have joined late. VVPAT also violates voter secrecy. It does not, because VVPAT information can be seen only by the voter, not by someone else. Okay, so we'll end it here. We'll meet tomorrow, and tomorrow we will discuss opinion poll, exit poll, compulsory voting, representation of the people act, and tomorrow we will also discuss previous year's question papers. And then on Tuesday, 6 o'clock in the morning, we will have the doubt class. So whatever doubts you have, you can send your doubts to islive@byju's.com, and we will pick all these doubts one by one on Tuesday. I will be taking the doubt class. Today we were Supposed to have the class till 12. Supposed to, provided we didn't have a class on Tuesday. And I told you at the start, we will have a class on Tuesday as well. So let's not extend the class beyond 10 because you have to watch the newspaper analysis as well. Plus, it can be information overload. We'll meet tomorrow, then day after as well, and finish. Okay. See you tomorrow, 6 o'clock. Till then, have a great time. Bye bye. All the best.